Good morning, colleagues. Welcome to Legislative Administration. Representative Pearson, can you lead us in the pledge?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. A couple of bookkeeping things. You'll notice that we're in our old double room here. But we are not scheduled to be in it. It's not a long-lasting effect that we have going. It will be just for today, I believe, and we'll be back to our scheduled single room, which I think is 203. We share with House Transportation. And I don't mind telling you that I sat there yesterday, and it's a little strange going back to the single room that we've been used to for years and years and years, but I've kind of grown accustomed to this double room. At any rate, that's item number one. Item number two is the scheduling that we have. Nothing changes on the schedule before you for the 9 a.m. hearing and the 9:30 hearing and the HR 25 10 o'clock hearing. What will change is the next two. But I will be addressing this again just before we break for lunch. 1367, the prime sponsor has reached out to me. He has a scheduling conflict for 10:30, but it also happens that he is a sole sponsor of that bill, 1367, but he also is handling House Bill 1096 that's scheduled this afternoon. So I have sent a note to him and with courtesy suggested that we can reschedule 1367 to either just before or just after House Bill 1096 this afternoon. Everyone understand that little tidbit? The next part is House Bill 1219. After I put this schedule together with our vice chair, this prime sponsor of 1219 came and said she wouldn't be able to access her experts that need to testify for today. So she has asked if we can reschedule that to a different day as well. So we're looking at the schedule now. Nothing has been scheduled, but again, just before noontime, I will open and recess 1219 to a date certain, probably the first Wednesday in February. And then we'll just move right into the afternoon. After lunchtime, I'll be handing the gavel to our vice chair, and all of the remaining bills will be done much more smoothly than the morning bills for that reason. So with that, unless there's any questions on the scheduling that I just mentioned, seeing none, we'll open the hearing on House Bill 1495. I recognize the prime sponsor in the room, Representative Gearhart. Welcome to Legislative Administration.
Thank you, Chairman. Thank you, committee, for hearing this bill. My name is Jason Gerhardt. I represent Northfield Franklin, Merrimack 25. So this bill came about from initially actually reading a letter that Thomas Jefferson wrote to James Madison, in which he states that no law can be permanent because no man is permanent. And he has a little calculation where he figures about every 20 years, all the laws should expire and then be reintroduced or reapplied for if they are needed. The point being is we need to figure out if the laws, as far as I'm concerned, are instituted to make society better, safer, so forth. But if they're not effective in doing so, we need to reevaluate what's going on because the repeal process is pretty cumbersome. So as far as New Hampshire goes, this bill would, dependent upon the percentage of the general court that votes in favor, give a lifespan to a bill. So here we go. 51% to 64%, the automatic repeal would happen 3 years after its effective date. If the vote was 65% to 79%, it would be 7 years. And if it was 80% upwards, it would be 10 years. The point being is if more people believe the bill is necessary, then it should last a little bit longer to see how it actually affects New Hampshire and society in general. And then there's another aspect to it towards the bottom, paragraph 4, number 4, where you see that if 100 registered voters apply to the Secretary of State to make sure they're actually really registered voters, then a bill for repeal of a bill, it'll go before the committee that has standing over it, and then they will decide whether to send it to the floor with a recommendation for repeal. So the concept being that the committees generally have a better concept of these bills and if they're efficacious or not, and can deal with them as such. So I think it's important for people to, especially younger people, to feel like they actually have a say in what's going on, and it's not just a bunch of laws that have been on the books forever that they have no connection with, and just really no feeling that they can change it besides minor. Let me back up. I worry sometimes that we try to edit and fix a bad bill instead of just letting it die and create something new and figuring out where we can go from here instead of just trying to tweak the same thing that hasn't been working. And as Ron Paul said, there's no such thing as a failed government program, simply underfunded ones. And I think that's kind of a major problem. So real quickly, I just quote from this letter that Thomas Jefferson wrote. The earth belongs in usufruct, which is the right to use and profits of something belonging to another, to the living, that the dead have neither powers nor rights over it. And the letter actually is, he was in France at the time and the French Revolution was kicking off. But his main concern was that if a government is able to contract debts greater than the current generation could pay off, it leads to the dogs of war being loosed, as it were. And perpetual war, empire building, and things we're all too familiar with. So that is why I introduced it. And I do understand that there are some concerns with the percentage basis aspect of it. I just didn't really know how else to institute the will of the people into the lifespan of the bill. I think that's key. I don't want to just have a universal, every bill lasts for 10 years. I think it should vary depending on the percentage of the representatives that believe it's needed. So if there's any questions, I definitely welcome them. I understand this is kind of a, yes.
Thank you. All done.
Thank you.
I'm going to take a prerogative and ask the first question.
Sure.
So just for clarification, you had said depending on how the general court voted, but I'm seeing here that you mentioned only the House clerk and how the bill passed from the House of Representatives.
Yes.
There's nothing in here that I could see that recognizes how the vote occurred in the Senate. Is that in one hand you mentioned general court, and
Yes.
the other you mentioned just the House of Representatives. So what are you thinking?
Understood. In my mind, I think of general court, the House of Representatives. I think it's closer to the people. I don't really think the Senate has as much of a connection with the people.
Okay.
No offense.
That was just my clarification. I saw Rep. Pearson's hand first.
Thank you, Mr. Chair. And thank you, Representative, for presenting your bill this morning. Throughout the RSAs, and it doesn't really matter which chapter, there is a tremendous amount of referencing. As an, and there's no need to give a specific example, but a lot of times what will happen, it will reference another part of statute. Not all of those things were enacted at the same time. So how would you deal under this premise? How would you deal with a piece of statute that references something that has now expired? Because law can't reference a piece of statute that doesn't exist.
I would leave it up to the expertise of honorable chairmen like Mr. Hill.
And specifically, are you familiar with RSA 1? Because the expiration of RSA 1 ends the state of New Hampshire.
Okay.
Okay, so if we, how logistically would we go about reenacting our existence when RSA 1 expires? Because under this, you leave no provision for the rare case of something that must be in perpetuity.
Well, I believe that would be the percentage basis for automatic repeal is for new legislation. But for current legislation, that would fall under Roman numeral 4, which is the 100 registered voters. So if we do have 100 registered voters that come forward and say, you know what, I think it's time to start over, you know, we're going to change New Hampshire to another state name or whatever, then it would go before the committee that would handle such bill. I don't even know what committee would handle that, but whatever it is. And then we would leave it up to representatives who represent the people and the will at large to figure that out.
Thank you, Mr. Chairman. Good morning.
Good morning.
Thank you for your testimony. Where else in our country is this happening? Is this the first piece of legislation anywhere in our country to reference this type of process?
As far as I understand, but I could be wrong. The automatic repeal or sunsetting of bills is not new. That I was actually doing some research on this a little bit, and in the 70s, apparently there was a major push to sunset a lot of federal legislation. Problem being, most of the major big agencies were exempted. You know, the normal thing, like the Pentagon can't pass an audit. You know, so yeah, I believe this would be the first.
Thank you. I'm going to hold questions for a while.
Thank you. So I have another one.
Sure.
If we are dealing with concurrent bills or bills that are on the same topic,
Okay.
how and one passes with an amendment that people in the House seem to want more than the one without the amendment, and the percentages change, how would you handle something like that?
On line 18, is if an act is further amended by another legislative session, the time until the prospective appeal will follow the percentage of members present voting ought to pass on the further amendment. Does that answer your question, or am I incorrect?
No, and it may be more that I imprecisely asked the question. But suppose there are two pieces of legislation in the same session
Okay.
that are along the same lines, and all that one does is perhaps have an amendment, and that has, for that reason, had a higher support. But they handle the same section of law. How would the clerk, how would any of us know which of these bills are going to be repealed in 3 years versus 10 years?
I would say we should err on the side of repealing sooner. In general, I don't really know if that would occur because each bill would have its own repeal date. So you're saying two bills deal with the same topic. My first question would be why we have two
the
bills
same
then?
the same section of law.
The same section of law. Yeah, I'm having a little bit of a hard time understanding that.
Okay.
So that's probably my fault.
No. Following up on that, what are you at all open to the idea that some sections of law should not be? I'm presuming that there could easily be a gap of time when law doesn't exist on a particular topic, from the repeal date before it gets reenacted. Suppose that would be during the time that we have a felony or someone that has to register on the sex offender list or something along of a very serious nature. Can you foresee a time when there would be someone that would fall between those gaps and therefore not have a piece of law affecting them and be able to be put on trial for that action?
I suppose that could happen, but at the same time, if we have 3, 7, and 10 years respectively to figure this out, I think simple planning could prevent that from occurring. If we know a law is going to expire in that many years, I don't see why that would be an issue when we already know that's coming up. For instance, the committee could then just, or not committee, a representative could then put that same bill back into effect ahead of time. I don't know. I just don't think that would be a major problem, but there could be perhaps some provision added in here. I'm not saying this is written in stone. I think we need some mechanism for getting old bills off the books that aren't effective and don't represent the will of the people currently, but just haven't been repealed because time is limited, obviously, in this house.
Again, prerogative here. Time is limited, you're right. But you're now making more of an infringement on time. You're having us rehash legislation that may have only come up 2 or 3 years ago automatically. Mm-hmm. And I'm not sure with Roman 4 why that can't be done now, not with 100, but simply one. Why can't 1 or 2 of any constituents talk to us about having a bill repealed now?
Because it wouldn't be an automatic process. You'd have to put the bill in, has to get scheduled and so forth, where this would just go right to the committee.
No, this is Roman 4 I'm talking.
Yes.
In Roman 4, that would have to be 100 people that would sign on to a petition somewhat. Why 100? Why can't it just be done with one now? One person can speak to you as a representative and ask to have a bill put in to repeal any section of law.
Understood. I just find this to be more. I think it would encourage more citizen participation in a way, and then it would just automatically go to the committee where they could review it. I just find it to be more streamlined. I don't know if that makes sense, but in my mind, it makes it more streamlined so they could just go to you, and then now you know, okay, there's at least 100 people in this state that just feel that this bill is not necessary. And then you guys just take a quick vote. It's 5-minute vote. Hey, up or down? No? Okay, boom, it's done. And then you have to wait another, every 2 years it can come up. You know what I mean? In my mind, it seems cleaner than having to schedule a hearing, this and that. It could be done on the committee's own time, whenever they want. Hey, we have these petitions. Let's look through them real quick, get it done. As far as... I forgot your first part of that question.
No,
Sorry.
that's fine. Thank you. I'm going to go with Rep. Sheehan. Okay.
Morning.
Good morning. Thank you for taking my question. You were just discussing about a good law that may be sunsetted, and there would be several years to make sure that it gets reenacted so nothing falls through the cracks. Who would be tracking that? Because that would be a lot of work tracking a lot of laws. Who would be doing that work?
I don't know. In my mind, it seemed like it would just be automatic. With the bill, once it's passed, it would have a date. I guess an Excel spreadsheet. I mean, I don't know. I don't think it would be that complicated to do technologically, but perhaps I'm wrong. Just you'd see, okay, these bills are coming up for expiration. Maybe you can make it so it turns yellow when they're getting within 6 months and just kind of go from there.
Yeah, but who would oversee that process?
I suppose the clerk?
Thank you.
Thank
Thank you, Mr. Chairman, and following up on Representative Sheehan's questions, our House clerk has an awful lot of work to do with
Yes.
scheduling everything all the time. I'm a little surprised there's no fiscal note on this because it's going to take more people than our House clerk to handle this volume? We have what, about 1,000 bills a year, 900 to 1,000? And that means someone's going to have to sit down and keep going through bill after bill after bill. And you know they're all published in those thick books. That's going to, how is this a manageable process?
If I may say, I think we got to think about the average person who lives in New Hampshire, not just the political class, but let's say a car mechanic and so forth. They have to know about all the laws, technically. Ignorance of the law is no excuse. So maybe we need to be cutting down on the amount of laws we pass. Just in general, I find it interesting that we talk about the volume of laws, but we don't talk about the volume of laws that the average person who's paying our salaries has to figure out in order to navigate every day. Now we can say, well, certain laws are specific, areas of it, but still, technically, we need to know of every law that's passed. And I just think there needs to be more check on those laws. And I think giving them a lifespan, like people, would kind of be a good thing.
Reps, follow up?
Thank you very much for your answer. I'm looking at Roman numeral number 4 down at the bottom of the page.
Yes.
And it says, upon receipt to the Secretary of State of 100 registered New Hampshire voters, a current law may be requested for repeal. And then it goes on in terms of the process of that. Sometimes it's not too hard to get 100 people to do something, but then you've got the whole rest of the state. Are we going to put this whole process before the House to try to figure out if something's to be repealed because 100 people from one community or one district want it? Or how is this going to work?
How would it work if 100 people say they wanted a bill repealed? Well, it would come before the committee, who has jurisdiction over it, or I don't know if the proper word is for that, but whoever has the oversight of that, and then they would just have an up or down vote. I just think it should be on the record. I think it's important. There's certain laws that I don't believe people really support anymore, but there's not enough political will to repeal them for various reasons, special interest groups. And I just think that this would allow now, I'm thinking of non-violent victimless crimes, a lot of those kind of bills. That's really what this was aimed for. I don't really care about nuanced tax law, state tax law kind of stuff. That doesn't really concern me. But it's things that people would end up on the wrong side of the law for and losing their liberty on. That's what I think is important to reevaluate frequently.
Rep Sellers?
Thank you, Mr. Chair. Thank you, Representative,
Thank
for bringing this forward, because one thing we do have is too many bills we pass every year, and 10 years down the road, we got 3,000 or 4,000, 5,000 bills on the books. So in addition to what we already had. So one of my questions is what happens to the bills that get stuffed into HB2?
That's a good question. I'll have to get back to you on that.
One follow-up. And I realize you're looking for guidance from us here as well, and it's not a 100% baked bill, but you're just bringing it forward for us. Are you expecting the repeal process or the process that you got here and to go before committee like us, or to go before the entire House for repeal?
So you're referencing Roman numeral 4? The 100 votes to I was thinking the committee would be a better environment because they have subject matter knowledge of the topics at hand, or supposedly do, if that makes sense. And they could just give an up or down vote. Now, if there should be some kind of mechanism to challenge that on the floor, I suppose that could be done. But yeah, I didn't really think that'd be. I'm trying to keep this simple. I got it down to one page, but it definitely could use a little bit of love. Not gonna lie.
I give you credit for that. Rep Pearson?
Thank you, Mr. Chair. You mentioned the lifespan of people, but this bill almost references the lifespan of a goldfish.
Yes.
Okay. When
So-
you're talking about three years, 7 years, 10 years,
Mhm.
we currently process, as on average, right, about 1,000 bills a year. We also overturn about a third of our membership each election.
Mhm.
Unless this passes, and then it would be about probably 90% in the next biennium. But my question to you is, do you have a grasp of the volume of work that would come forward to a volunteer legislature if this was enacted 3 years from now with a House that's virtually 50-50? Do you have a sense of the volume of the workload?
Let me address the first part first. The reason Thomas Jefferson's calculations of all laws, and he included the Constitution. I don't think we really should go that far, but he figured it was about 19 years, a generation of men, and so forth. The reason I went with 3, 7, and 10 is they seem like good numbers, but also because nowadays it's much easier to see if something is effective. You can tell if you pass a law, if it reduces or eliminates the problem for which it was intended pretty quickly with technology. It doesn't take 6 months to send a letter from New York to London. So I think the time span can be sped up drastically. Secondly, as far as the volume of work, I would again refer back to my previous comments. I think if we're requiring the average person who lives in New Hampshire to know all these laws, then the least we can do is look at these laws every few years to figure out if they're actually doing what they're supposed to do. I don't know. I just have a simplistic, perhaps, notion of laws and the purpose of legislatures, but I think so. This also came about real quickly. I was reading about, I forget which Scandinavian country it was, but back in around 1000 AD, they had a title in the government called the lawgiver. And every year, he would have to repeat verbatim from memory a third of the law. And anything he didn't remember or speak was removed from the books. So the whole point being is if you can't remember the laws you've passed, A, maybe we have too many laws, or B, maybe they're too complicated. For instance, just real quick, federal law, the IRS code, 60-something thousand pages. And we're expecting the average guy, who's a veterinarian or works on cars to figure that out. So that's kind of where I'm with that, if that makes sense.
Sure. Last one.
Okay, so I'm kind of the average guy. I have a full-time job. I own a house. I have a dog. And I volunteer to come up here weaving in and out of all of that. And I agree with Representative Wall about the lack of a fiscal note here. Are you simultaneously advocating then for this to become a full-time legislature in order to handle the workload that will come from this proposal?
I'll just answer that with one word: never. No, I think the part-time legislature is key to the New Hampshire experience, as it were.
Thank you. One thing I would ask is you to complete a pink card.
Oh, sorry about that. Yeah.
Yep.
You got it. Thank you.
Other than that, I think we're good. Thank you very much.
Thank
for
you
your
very much,
testimony.
committee.
Appreciate
Appreciate
it. I have no other pink cards on this. I do, actually. Our house clerk,
I didn't fill out a pink card, but I will. Can I speak real quick?
if you fill out a pink card, sure. The chair recognizes our house clerk.
Thank you, Mr. Chairman and members of the committee. As you know, Paul Smith, Clerk of the House, as usual, not testifying in support or opposed to legislation, merely providing you some information. Last week, I briefly spoke with the sponsor of this legislation, expressing some concerns. He asked me how I thought he could make the bill better. The only way, truly, I think he can accomplish what he wants is that any prospective legislation going forward would have an automatic repeal date. That's the only way I see this new mechanism working, because otherwise this idea is novel, and I say that in the true sense of the word novel. I'm not suggesting that putting in an automatic repeal is a good idea. I'm just suggesting that that might be what the sponsor is looking to do. Other than that, I do have some concerns I'd like to share with you, specifically that the language is vague, confusing, and not at all correct in terms of structure. In Roman 4, for example, it refers to the appropriate statutory committee in the House with jurisdiction over the subject matter of the bill. It then goes on to speak of the bill to be repealed. I assume that this should be standing committee of the House, as a statutory committee is defined in RSA 1449, as this committee knows just about better than anybody else on the planet after having worked on this issue for the last 3 years. To Representative Pearson's point, structurally, what happens when the House is out of session for those 6 months every year? Specifically during the summer and the fall, in the citizen-initiated drive to repeal a law. By the way, it isn't a matter of repealing a bill, because once a bill is signed, it is law. I want to make that distinction clear. It's not just a bill anymore, it is law. Here's another point that's concerning. In order to repeal a law now, it has to go through the entire legislative process, meaning both bodies, and signed by the governor of New Hampshire. The language in this text ignores the other branch of the general court. Now, granted, I am a bit adversarial to the other side of the wall, as you all know. But we are still a bicameral legislature until you all pass a CACR to become a unicameral legislature. And frankly, this language ignores the deliberative nature of the general court by having public hearings or involving the Senate. And admittedly, as a product of the House myself, I can't ignore that there's no mention of the other body and their abilities as a co-equal part of the legislature. Therefore, I am concerned about the constitutionality of this legislation. I did speak with the director of OLS last week and inquired about the lack of a fiscal note because as the clerk and chief legislative officer of the House, I can tell you I will need to hire somebody, if this were to become law, to work exclusively on this novel idea of tracking all House passage of bills by percentages. Possibly session only, but it would be a devoted staffer nonetheless. Additionally, as this would be a new process involving not only the legislative branch, but the Secretary of State as well, I assume there may be additional encumbrances felt by that office in order to fulfill the novel mission of this legislation. Additionally, as this committee well knows, having worked extensively on RSA 1449, there have been workarounds since that legislation was passed. Our new favorite word is notwithstanding. And legislation is frequently drafted now that says, notwithstanding RSA 1449, a commission consisting of 900 persons shall be formed doing whatever. And I am concerned that, you know, even if this were to pass, the notwithstanding loophole would essentially become part of any piece of legislation moving forward. And that would be perfectly allowable. Lastly, we don't simply nullify in the legislature, my friends. We do not simply nullify. This language in Section 4 is a form of direct democracy that was not envisioned by the framers of the New Hampshire Constitution. Otherwise, it would be explicitly enumerated. So given those points, I felt it necessary to share with you those concerns regarding this piece of legislation.
Thank you, Mr. Clerk. Any questions? Seeing none, thank you very much. I have one last pink card on this this bill. The chair recognizes Representative Potenza, who indicates she's not supporting or opposing, but apparently wishing to amend. Welcome to Legislative Administration.
Thank you. So of course, I'm here to testify on the next bill that's up. So I just wanted to speak literally 1 minute on this, only because I understand where the sponsor was coming from. And I believe, especially being a new rep, let's just talk about the volume of bills, 900, 1,000, or what runs through. And there's no checks and balances. That's really the problem. There's no one that's telling you, and they're all paid in OLS, hey, this bill is really unconstitutional. This shouldn't be filed. And that would decrease the level of bills that are coming in. And I don't know if it would be germane to amend it like that, but there needs to be like checks and balances that are in there. And instead of us, of course, and I understand where he's coming from, we're passing all of these laws, right? And a lot of them that are on the books, there's tons of conflicts in statute. I know we're handling it. I know HHS is handling some of those conflicts. They're being handled in committees all the time. We handled it 3 times last time, where we're basically passing something to make it make sense because it says one thing over here and says another thing over there. I mean, I think going through all of our laws on the books and really showing where they are, unconstitutional, and repealing them is totally a pathway. I think we should be focused on that as the legislature. It's kind of like a dual thing. I have no idea if that could be amended here, but in a sense, that's where I kind of hear where he's coming from, because we get very, very busy pushing things through. And, there's a lot of laws that are on the books that if they don't have any enforcement mechanism and no teeth, they're not worth the paper that they're written on. So making the book bigger, it doesn't help. So I just wanted to give my 2 cents on that.
Thank you very much. Speaking out of turn here and for the whole committee, I don't think we are adversarial to the idea, and I do personally appreciate any kind of new idea that comes along that can address the volume. I look at it as just the opposite. I think this increases the volume exponentially. I think we'll be looking over bills that we just looked at, but I too can be wrong. I think I don't want to squelch new ideas coming forward, though, and I do think that is to be applauded. Thank you for your time. Having no other pink cards, I think I'm ready to close the hearing on, I lost it, House Bill 1495. There'll be a minute here to reset, and then we'll start in on House Bill 1666 FN. The time being 9:40, we'll open the hearing on House Bill 1666 FN relative to income reporting requirements for lobbyists. Chair recognizes the prime sponsor, Rep. Potenza, who has obviously in support of the bill and says she needs 3 minutes to discuss. Welcome back.
Thank you, Mr. Chair. I come to you today. This was probably one of the first ideas I had to put in a bill. Most of the other ideas came from constituents. And just from the experience of being here, kind of as just a regular Joe activist and coming to testify at committees and now being a part of the legislature, I've just noticed some real issues. And I sent this bill idea out to the entire House, and I got a huge amount of response. This is a nonpartisan. I heard from just as many Democrats as I did from Republicans that are interested in this, and they had to be turned away because not everybody, of course, can be signed on as a co-sponsor. requiring lobbyists to report their income, it's really crucial for transparency and accountability in the political process. When lobbyists disclose their income, it helps identify, of course, potential conflicts of interest between their financial interests and the policies specifically that they advocate for. So this transparency allows the public and policymakers to understand the financial relationships between lobbyists and their entities and the industries, of course, that they represent. Full disclosure of income expenditures by lobbyists, of course, helps prevent corruption, undue influence, unethical practices in government decision-making. It allows for a clear understanding of who is attempting to influence policymakers and to what extent, fostering a more transparent and equitable democratic constitutional republic process. Additionally, it enables regulatory bodies to monitor compliance with lobbying laws and regulations, and of course, it ensures that lobbying activities adhere to the same ethical standards that we all do have to in the legislature or as holding political office. So I think one of the biggest concerns about with politicians, associations, corporations paying lobbyists isn't inherently about the act itself, because especially for seasoned legislators that are here, it's a legitimate way for various interests to communicate their viewpoints to lawmakers. They have they get paid a lot. We get paid $100, so they get paid a lot, and they have research teams and things like that, which is great. So having that information is wonderful. But there's potential issues that arise when that relationship pretty much between these entities, politicians, lobbyists, corporations, all of that kind of stuff, involves conflict of interest, lack of transparency, and undue influence. So I believe that this bill can help right a ship that I think is steering in the wrong direction. There's been so much that I will send you my testimony. There has been a lot of stuff that's been printed on this for several years. And just in 2019, there was a wonderful article that was on NHPR that says, you know, as lobbying in New Hampshire grows more complex, it's nearly impossible to follow the money in New Hampshire. That's a problem. So I asked a question. I'm in the Stratford County, along with Representative Wall. So we're, you know, our delegation, smaller than, of course, you know, Rockingham and Hillsborough, and just to kind of understand the level of, you know, lobbying efforts or people that are hired to do government relations and things like that. So there's a, you know, it's a county association that has all of the counties that are part of it. And I just didn't understand how the county association, which is all elected officials, who's paying into that association then to pay a lobbyist when that lobbyist is here working against legislation that is representative maybe of a Republican principle. So there's so much conflicts of interest. And when I asked those questions to one of the lobbying groups here in New Hampshire, I got back like where this, you know, New Hampshire Association of Counties, for example, is paying tens of thousands of dollars. That's our money to then be used against potential legislation that I could file or others can file. It just seems like a circle that needs to be cut off. And I can give lots of other examples that I've seen through agencies that are really concerning, where, you know, an agency says that they don't have any stake in the game, and then they come and they send letters and testimony, and then you automatically see that the same talking points that are coming from the lobbying group is what the agency is saying, and lots and lots of meetings that are happening in these agencies that are working against the legislature, where in a sense we're supposed to be kind of the driving factor with different agencies, whether it be, you know, DES, there's just HHS, there's a lot of that stuff that's going on. So that's why I filed this bill. I've got overwhelming support. I have one amendment that I'm going to make, and the only reason why it wasn't put in was because, this came to me when OLS was backed up. I had a change. They couldn't put it in based upon the deadline. It is on line 9 on page 2, and it says the amount, dates received, and source of all income earned by the lobbyist in the prior calendar year in excess of $5,000, and then we wipe out for lobbying activity. That line gets wiped out, and then whether paid directly by the client, the employer, or other third party. That is the change. I'm going to take out those 3 words, so there'll be amendment coming in for that, and then I can send you a whole bunch of resources about this as well. So, any questions?
I don't know. I will ask. Rep. Pearson, you have a question.
I do. Thank you, Mr. Chair. And thank you for presenting this to us this morning. I'm trying to grasp a practical reality of this activity. So here's my question to you. The NRA has, as an organization, lobbyists in New Hampshire.
Mhm.
Okay. Would that lobbyist who works for the NRA have to file a massive report showing all of the income, the sources, and the work that the NRA does nationally, because it's not an outsourced lobbying firm. They don't pay a firm that's like across the street that we have, the lobbying firms that exist in Concord. They send their person directly from the organization. So how is that logistically going to work when you have a national organization coming to lobby before this body?
So this really speaks to all of the processes that have been in place for a long time. So, for example, if I'm going to register for a lobbyist, I've got to have an orange badge. I'm kind of walking around all the halls here. This is really what that applies to. If someone is coming in to speak, let's say they're a guest speaker and they're working for a national lobbying group, they are not coming here to New Hampshire. They're not working in New Hampshire. They're not filing and having to give that kind of information to be registered here in the state. They don't have to have an orange badge to come testify. That's not happening as frequently as what I'm talking about. This bill speaks specifically to the folks in New Hampshire, is what I'm talking about here.
I'm sensing there'll be a follow-up.
Only because that's not how it works. The NRA, if they bring a lobbyist to New Hampshire to testify, they have to register. That's not optional. So they're not coming up here to speak as a private citizen. I'm just using it as an example because they're a large national organization. They are not exempt from our very specific lobbying rules that exist in this building. So I'm just trying to get the practical reality of how they will comply with this if it passes.
So, based upon my knowledge, so for example, this was before I was a state rep, there was a doctor that was part of an association, in a sense, that came here to testify. They said that they were coming on behalf of themselves as a doctor, not as that association, which is a lobbying group as well. They didn't have to register. They came in, they flew in from another state to testify. So I understand where you're coming from, but those are one-off situations. They are not, if they are here testifying on a regular basis, they're going to have the orange badge. That's not happening what you're talking about. You're talking about like one-off situations. Anybody that is here on a regular basis that registers with the state to be able to testify on a regular basis, you guys know, you're in the committees, they're here all the time. How many are here right now? So we see the same faces over and over. That's what I'm talking about.
I think I can clarify a little bit. There's a miscommunication going on. There are organizations that are national organizations that have lobbyists here that are registered lobbyists. They do qualify under the lobbying category. The concern I think the representative has is when they belong to that national organization, they would have to, under this, the language of this, would they not have to list all of their lobbying nationwide for the entire organization? That was, I think, the question. It's,
So they are listing under 3, the amount, dates received, and source of all income earned by the lobbyist in prior calendar year in excess of $5,000, whether paid directly by the client, the employer, or third party. I'm here, I'm coming to testify, I work for the NRA, I get paid $70,000. I'm going to report where that income is coming from, who my clients are. That's it. We're not having the NRA disclose every entity that's paying them. No, this is specific to the employee. The person it's just exactly, think of it like us. What we have to report, every single one of us here has to do disclosures and report that kind of income. That is what I'm asking. We're asking for the same playing field that the politicians have to do for the people here that are following legislation a lot more closely than most of us that are in that 400.
thank you. Other questions, comments? Seeing none, thank you for your testimony. The next pink card I have is for Representative Gerhard, who says he supports the bill and needs 2 minutes.
Actually, less. Representative Gerhard, Northfield Franklin. So I'm actually a co-sponsor on this bill. And I was just going to speak to the financial fiscal note. So the Secretary of State believes that they'll need to hire a new employee to monitor the filings at $35,000 a year. Somebody said no. Oh, that's all right. So my only suggestion would be that this fee burden be taken on by the lobbyists, some way, some shape, some form, some kind of fee, just to offset it from the actual general public. Just a minor note. That's all I only need a minute. Something like how New York City has the taxi medallions. So we need little lobbyist medallions. All right. So that's all I want to say. Thank you.
Thank you. Further question? Would you,
If you're willing to take it.
Sure.
Just so I understand you. You are going to require someone pay a permit to speak in front of a committee in a public hearing.
It's a fee to offset the cost of
That-
monitoring their compliance.
Okay. So the answer you're giving me is yes.
Mhm.
Okay.
thank you. We have a late entrant. You were also looking for written testimony, right, on this? Rep. Tenza, you mentioned that you had testimony, but also a written amendment. Is there an amendment coming? Yes. Thank you. Sorry about that.
No, you're fine.
Do I have a pink card for you? Ah. We have before us Olivia Zink, and supports the bill with edits, and is asking for 2 minutes representing Open Democracy.
Good morning, members of the committee. My name is Olivia Zink. I'm a voter in Franklin, and I represent an organization called Open Democracy who believes in transparency. And I think what this bill is trying to get to is additional transparency. I do want to say that on line 5, the name, address, and phone number of the lobbyist is something we already do. So probably not additional need to the statute. On line 9 for prior calendar year, currently lobbyists file April 24th for the period of activity, January, February, and March. They're filed quarterly. They file quarterly reports. So I do think line 9 needs to sort of be consistent with the quarterly reports unless we want to change these reports to annual, which I don't think is probably needed. Quarterly is probably acceptable. Yeah, quarterly is, you can keep that. On line 20, I think that it would be important for the Secretary of State and the Attorney General to look at who enforces these laws. I did write to know the Attorney General to see how many enforcements they've done on lobbying reports, and I got a big fat 0. They've never enforced this law. So I think that it's more important that the law get enforced, whether it's the Attorney General or the Secretary of State or who does that. I do like this notion that on line 28, whereas if a lobbyist is 10 days late filing the report, the Secretary of State sends an email notifying them to complete their report. I do want to tell this committee that on September 21st, 2021, there was a note from the Attorney General to Bill Gardner on how to file the laws because they're confusing and lobbyists fill out these things inconsistently. I do recommend the committee read this Attorney General's memo because right now every lobbyist fills out reports differently. And I think it's important for us to realize how many lobbyists pay $50 annually to register. 10 years ago in 2014, we had 249 registered lobbyists. I tried to pull up today's numbers, but there wasn't a spreadsheet yet. I think it's just because people are still filing registrations for the year, so it would be interesting. But in 2008, here's the list of registered lobbyists. It's 89 pages long with 10 to 11 names per lobbyist. So we have had a huge growth in that. I do also want to point out Open Secrets ranked all 50 states with a score of 20 on state lobbying disclosure, and New Hampshire gets a 10.25. So we're getting half of what we should be for disclosure. Timely, but user-friendly, so people can find this information, we get a 0.75. Our system is not user-friendly. It's done on paper, quarterly. There is no way to email your lobbyist report to the Secretary of State. You can only fax it or hand deliver it or mail it. So maybe thinking about, it's a fillable PDF. Why not let them fill it, send it into the Secretary of State? That way the Secretary of State doesn't have to scan all of these reports. Then when you try to find it on the Secretary of State's website, good luck, because it's really difficult to find them. But I did bring examples of multiple different lobbyists who fill out these reports in wildly different ways. So right now there's just very inconsistency of how lobbying reports are filled out, and maybe we could look at simplifying the form and making the form clear, because the form says by all your clients, and some people do the totals, but it should be of that client that you're filing the report for, which is, you could change the way the form is read, and I think you might get more compliance. I'm happy to take any questions.
Thank you. Are there any questions? I have one. I had circled the part on line 3 for a single, clear, concise, and accurate financial disclosure statement. We would all like to think that our financial statements are clear, concise, and accurate. But it would seem to me that if there was a single form, it would make it easier for anyone that has to try to weed through any of these financial statements in order to get the correct information. Is that clear?
Well, currently you have to fill out your cover page. Let me just say, there's multiple pieces of paper that a lobbyist has to fill out. They have to fill out this piece of paper with the name of their lobbyist, the name of their partnership firm or corporation, and the period of which they're filing it. Then they have to do an addendum A, and the addendum A is several pages long, which lists the amount that's paid in that period, and the expenses, so the fees received and the expenses. You then have to do an amendment B, and the amendment B is if I bought you a cup of coffee, I'd have to write that I bought somebody a cup of coffee, or whatever. I think that there is a limit, so maybe a cup of coffee doesn't qualify. I think it has to be over $5, but sometimes coffee
A Tesla.
can be $5. Actually, we can't gift lobbyists can't gift you anything more than $25. So, if I'm going to buy you a few beers, I have to buy Bud Light and a couple of them, because I can't give you more than 25. Then they have to file a addendum C, which is any political contributions that lobbying firms made. The addendum Cs are frankly the messiest part of this process because many lobbyists make political contributions, but the addendum Cs don't reconcile with our campaign finance reports. I've tried and I can't get addendum Cs. And then there's another piece of paper that the lobbyist has to file. So you've got your addendum A, your addendum B, and then you have to file this signature form. So the amount of pieces of paper each period is pretty repetitive and could be simplified, I believe. And I think there was a committee that looked at this a couple of years ago. But I also think with our online technology, filing these by paper might not be what we want to do. We might be able to make them fillable PDFs and be able to submit them. But currently the law says they have to be printed and hand delivered or faxed or mailed.
Great, thank you. I think that did answer exactly what I was trying to get to. Seeing no other, thank you very much for your testimony. I have no other pink cards, correct?
Nope, we're good. That's it.
I think we're all set. Thank you. I'm going to close the, perfect. Thank you very much. Before I close, no, I am going to close the hearing on House Bill 1666 FN. Be a couple minutes here and we'll reset and pull up House Resolution 25. Okay, a few minutes late. I apologize for that. We'll open the hearing on HR 25. Couple of quick statements on this. We do have a hard stop at noontime. And then I'll have a couple of informational notices for the committee. At that point, we're going to rearrange some of the schedule beginning just at 12 o'clock for the afternoon session. I would ask, as we call you to the witness table, that you state your name and the organization or whom you are representing, and whether you're for or against. And most of that is for the recording that we're doing simultaneously. I don't want to limit the time speaking. Never like that personally. But it looks to me like everyone's asking for a reasonable amount of time, and it would seem that we can fit that into prior to the hard deadline. Please, if you can, concentrate on giving us new information. If you agree with a prior speaker, simply say, I agree with the prior speaker, rather than try to tell us the same information over and over again. That would be helpful. I do want to keep the conversation to the resolution itself, not to any of the underlying issues. And beyond that, are there any other instructions that we have?
Written testimony whenever possible.
I've been reminded by the clerk, written testimony is always good. 2 minutes is sometimes hard, and some people like to prefer or like to give us written testimony. That does go in the file, and I will personally promise that I do read all of the written testimony. Other than that, I think we're good to go. The chair will recognize the prime sponsor. If I can find the card. There it is. Rep Panic, is that correct? Did I pronounce that correctly? You asked for 3 minutes. Welcome to the Legislative Administration. Thank you for your testimony. Red light. There you go.
Thank you, Chairman and honorable members of the committee. My name is Representative Sandra Panic. I'm from Pelham, New Hampshire, Hillsborough District 1. I want to start off by reading something off my cell phone. Mason's Manual, Chapter 2, Section 7, Paragraph 1, says that the constitutions stand on a higher plane than statute, and as a rule are mandatory. There are statutes regarding election process which conflict with the New Hampshire Constitution. This resolution nullifies any conflicting statutes by resolving to return to strict observance of the original law, New York Pistol and Rifle versus Bruin, shows that the original law is the highest standard in America. And I have a little additional blurb I want to read. We are a constitutional republic, and so we are answering Ben Franklin's challenge to endeavor to keep it. Remember, we all took an oath to the New Hampshire Constitution as well as the United States Constitution the day we were sworn into office. We must all remember that our rights are not just on paper, but lived and breathed every single day. Oaths bind the party to observe a certain course of conduct or to fulfill certain duties in the future or to demean himself thereafter in a stated manner with reference to specified objects or obligations. This is what legislators are committed to do when we take our oaths. With regards to the towns who voted to use machines, they are all creatures of the legislator and cannot override the law. For example, a town no more vote to have machines count in their town than they can vote to ban gun ownership in their town. If random towns could vote to override the Constitution, that would be called an arbitrary power. The law says that arbitrary power exists nowhere in a republic, not even in the largest majority. Are we being viewed as troublemakers because we want hand counting? The pro-abortion crowd views us as troublemakers for wanting to stop the murder of babies, and yet we press on because it is right. It is simply the law to hand count. Each town will suddenly get very motivated to be efficient with counting once they see their votes won't count if they don't do it by hand. Don't forget, if this passes, even the Democrats will rally with the Republicans to make sure they get counted on time because they want their votes to count just as much as we do. But we have some good suggestions too that we can make. But the success of H.R. 25 resolution should be tied to the mere truth of defending the law, not escaping being seen as troublemakers. Cost analysis may be a helpful tool. However, there are some legislators who do not care how much the machines cost in terms of not having them at all. To some, the ability to cheat and not have to stay late counting far outweighs any cost. And for those who know, we don't care how inexpensive they can be. We want them gone. This is the law, and it's written in our Constitution. The reason 640 election lawsuits failed is they all alleged fraud, which cannot be proven without eyewitnesses. Instead, to claim maladministration, not following the rules, would have gotten us all somewhere. So now is our chance. We keep it simple. The rules must be followed, or the result is impossible to know and certify. Maxim of law. Where the law prescribes a form, the non-observance of it is fatal to the proceeding. If you have not heard about this resolution, it's important to understand what it means with regard to preservation of your position, if your position is important to you. Without this resolution, you stand to lose your lead in the House by 2024 and possibly never regain it. This is a nonpartisan resolution which helps preserve our positions. I will not be taking any questions, and I will be handing this over to our constitutional experts to answer your questions. Thank you for your time.
Thank you for your testimony. Can I ask one question? Do you have written testimony that you are? That would be great. Thank you very much. Sorry for the question. I'm going to break a little bit with our normal pattern here, but only in the interest of time. Our House Clerk has duties that he needs to be somewhere else, so I'd like to call our House Clerk, Paul Smith, to the stand. Welcome, Honorable Clerk.
Thank you, Mr. Chairman, members of the committee. Again, Paul Smith, Clerk of the House. I'd like to thank the member for quoting my favorite book, Mason's Manual of Legislative Procedure. I actually have a couple of other sections of Mason's Manual of Legislative Procedure that are important for this discussion today. Again, not here opposed to or in support of this legislation, merely to provide a few conceptual points. Number one, ladies and gentlemen, this is a House resolution. It has no effective law. It is very important to understand this would state a position of the House of Representatives and the House of Representatives only. It does not speak for the general court. Therefore, sections contained within, specifically in the resolving clauses, where it says resolved by the House of Representatives that the general court blank intends to do, etc. Again, this resolution does not speak for the general court and therefore does not contain any fact of law included in it. Additionally, looking forward to additional resolving clauses. where it says specifically on page 3, beginning in Roman 5, intends to require equivalent rigor of witnessing standards submitted to the people's demand for equal voting rights, a common benefit from elections, and no unequal classes of unqualified voters, and specifically requires the Secretary of State to follow actions later. We can't do that, ladies and gentlemen. That the only way that can be done is by amending law and addressing that in statute, or specifically through constitutional amendment concurrent resolutions. The section of Mason's manual, I found it prudent to discuss with you as well. As many of you know, this is a matter of adjudication between private parties and the state of New Hampshire, and is currently before the New Hampshire Supreme Court. Arguments were delivered late last fall, and the Supreme Court is deciding what they're doing at this moment in time. If this was a piece of legislation where it would effectively have something to do with law, there's no issue with that. But because this is a resolution specifically where it talks about our positions, I would remind you, in Section 112 of Mason's Manual of Legislative Procedure, any matter awaiting adjudication before a judicial tribunal shall not be debated or discussed in a legislative body. I want to repeat that again. A matter awaiting adjudication before a judicial tribunal shall not be debated or discussed in a legislative body. Again, this is different than a bill. This is a position statement in the form of a resolution. And therefore, I do think that you have some concerns that you need to address in how this resolution is drafted because of that very language. And I'm happy to answer any questions.
Thank you, Mr. Clerk. Are there questions? Yes, Representative Pearson.
Thank you, Mr. Chairman. Thank you, Mr. Clerk, for coming before us. Your knowledge and expertise on Masons is unquestioned. Let's run this through the process. It passes the House. Then what happens to it if it passes the House?
Thank you for the question, Representative. As you know, a House resolution simply is a position of the House. Nothing happens with this this resolution, because there is no instruction for the clerk to follow. It merely states your intention. However, the intentions that it states has requirements in it specific to requiring the Secretary of State to accomplish certain means that go beyond the authority of this one body of the bicameral legislature to enact.
Follow up? Anyone else? I have a quick question.
Yes, sir.
The section of Masons that you just stated, do we have a problem with the hearing itself? Or
No, sir. I would suggest not, because it is a duly filed piece of legislation by a member of the House. Therefore, it is certainly within your purview to take up that piece of legislation. I would just suggest that as the matter is pending before the Supreme Court of this state, that perhaps a decision, you might want to wait for a decision to come before reconciling that through executive session later this year, or potentially study the issue further.
okay, follow up. If the resolution comes through the executive session here and goes to the floor, does the debate that takes place on the floor have issues with Masons?
I think that there are some concerns about what you can talk about within the framework of what's contained in the lawsuit, especially as we are a party to that lawsuit.
Thank you. Any further questions? Seeing none. Thank you very
Thank you,
much.
Mr. Chairman.
Now we'll revert back to protocol, which is to bring up representatives first. I have Representative Gerhard, who is asked to speak for 2 minutes and supports the bill. Welcome again, Representative Gerhard. It's your lucky day.
Yes, thank you. I just want to make clarification. So Representative Gerhard, Northfield Franklin.
Thank you. For the record, can you state name, town, and who you represent, and your supporting or opposing the bill? Thanks.
Yes. Jason Gerhard, Northfield Franklin, and I am supportive of this bill. I'm actually a co-sponsor on this bill. I misspoke. I am not a co-sponsor on 1666 we just heard. I don't know how that happened. Okay.
We let you get through that one, don't
Yeah, I noticed. Appreciate it. This, as far as I'm concerned, this bill simply reasserts things that we already hold to be true. You take an oath, you should follow it. The Constitution should be sacrosanct because that's the rule book we're following. And I just want to say real quickly, as far as the electronic counting machines go and all of that, it's clearly unconstitutional. And I feel that more and more people are losing faith in the system of voting. And I think that is part of what this is trying to rectify. Because if people lose faith in voting, then we're really headed down a bad road. Because as JFK said, those who make peaceful revolution impossible make violent revolution inevitable. And I do hold that to be true. And I think history has proven that to be true. So I simply think we should go back to basics, start following the Constitution, and every vote counts, especially when it's done by hand and not just by some computer we're hoping is doing the right thing. So that's all I wanted to say. Thank you.
Thank you. You take questions if we have any?
Of course.
Are there any questions for Rep. Gerhard? Seeing none, you're off the hook.
Thank you.
Next pink card I have is for Rep. Potenza as well. Sure, but I'll determine the order here. Thanks. I have Wayne Saya, Senior, asking for 5 to 10 minutes. If that could be less than that, it would be terrific. I see you have testimony. We'd be happy to take that testimony.
As fast as I can.
Thank you for your help.
Okay.
Welcome to Legislative Administration.
This is my first time. I'm a retired CEO out of Nashua, New Hampshire. I've been there for 30 years. And I'm here because of the term legislative intent.
Can I interrupt for a second? Can you introduce yourself and who
sure.
you represent and your support or opposition to the bill?
Thank you. You recognize I haven't been here before. My name is Wayne Saya. I support the bill. I am a former CEO living in Nashua for the past 30 years, but working out of D.C., where my office was. So I did a lot of flying. And I support the bill individually on behalf of myself because of the tens of thousands of dollars I support candidates in the state within the past 30 years, which is probably now over a couple of $100,000. And one of the, I've been an electronic design engineer. I hold 2 U.S. patents with regard to electronic designs and frequency. And I also have written a book with regard to the safety of buildings and facilities, where I've taken care of a number of those facilities on Capitol Hill, in Boston, with the John Hancock Tower and so on. So I won't belabor that with you. If you want my resume, I'm happy to give you all 15 pages of it. Okay. The reason I support the bill is because of the term legislative intent that I've been hearing. And I participated in a recount election in Nashua just a couple of weeks ago. And there was an extremely large number of absentee ballots that were used in that election, none of which the Board of Aldermen would want to take a look at with regard to the affidavit. And we're not talking about examining the signature. We're talking about the legitimacy of the affidavit itself. They refused to hear it. But most importantly, I found quite bizarre is that this legislature passed bills that stipulates that the school districts shall run the elections. And it's plain right inside the laws. But yet, all over the state, because of the term legislative intent, Board of Aldermans and the city councils are running the elections against what the statutes call for. Statute, to me, was pretty clear. It's in front of a couple of judges right now who just don't really want to rule on it because you've been doing it for so long. So, because of the term legislative intent. Now, when I see a piece of legislation that says the school district shall run the elections in this way, and then that law is pushed aside because of legislative intent and because of the way we've done things all along, and they're having the cities and towns run the elections, to me, that's a problem with regard to education. With regard to elections, you've opened up a Pandora's box with regard to not following what I believe the constitutional intent is. Because now they brought in electronic design into this issue. And I've had heart surgery on a couple of occasions. So there are certain frequencies I can't go up to. And there are frequencies that people who wear pacemakers can't go near. And when you're talking about these particular people, they decide not to vote because they've been told by their doctors, don't wear a Walkman too close to your pacemaker, don't go too close to election machines because of the frequency of the timing mechanism that's used in those machines. And so therefore, the way that votes used to be counted was just the way that it stipulates within the Constitution. All of a sudden, you've introduced electronic systems, and the only way to protect from those systems, the legislature repealed it a few years ago and made this called an OSHA state. And now that we're in OSHA state with regard, see, anytime you have an electronic device, it has to be what's called safety certified, meaning it falls under Underwriter Laboratories or the other 21 safety certification companies that do that. The machines that have been used in this state for the past 15 years, they lost their certification 8 years ago, which means OSHA is not allowed now to use that. So when that was brought into court, the court says, well, the legislative intent says that it's probably okay. Nobody's ever brought it into federal court. Because if they did, the federal court would say, oh, you're in violation of OSHA. And so when you try to bring it into the state court says, well, that's a federal issue. And all the state has to do is just follow the Constitution and follow the constitutional intent of what it says. Go for the safety of the people, such as myself. I mean, I haven't now donated to a Republican cause in 2 years because of the term legislative intent. So I think the legislature, maybe starting from this committee, and I'm not saying this to belittle anybody, but you guys need to get your act together and start looking at who's voting and who's not voting because of electronic devices that have been incorporated into the state that have now caused a potential hazard. The reason why OSHA is there is not because of the hazard itself, it's because of the potential hazard. And that's what OSHA is there for. Either that or go down to some electronics committee or tell them to reestablish that bill that they repealed. That way the state can now take a look at the machines. But I'm saying this because I'm a professional witness for 7 different attorneys in New Hampshire. And I've told them all this, and they said, well, Wayne, this is too political. Can you just write to this issue or that issue? Because there's probably a problem with the legislative intent of what you're saying, and we don't want to scare the voters of the city or the state. And I'm saying, well, I'm not trying to scare anybody. I'm just, what did Truman once say? I'm not trying to give anybody hell. I'm just giving you the facts, and it sounds like hell. So that's all I have, and I'm happy to answer any questions.
Thank you for your testimony. Are there any questions? Seeing none, thank you again.
It's my pleasure.
First time you can't use that anymore. Now that you're done, you're a veteran. Is that written testimony? My clerk just reminds me, is that written testimony that you have for us?
It's not. It showed me how to get here.
Well, it obviously works then, right? Yeah. Thank you. You now? No? Okay, hold on. Next, the chair will recognize David Kiley. Ask for 3 minutes in support of the bill.
Handouts?
Welcome to Legislative Administration.
Thank you. You guys want these?
Yes, yeah. What? That's number 5, yes.
Good.
That's
Yeah.
number 5.
If you could introduce yourself and who you represent, and
My name is David Kiley. I represent myself in support of HR 25 as one of the people in Part 1, Article 1, exercising my right to give notice and instruction in demand of exact observance to the fundamental principles of our Constitution under Part 1, Article 8, 32, and 38. I'm going to get started. I'm not sure everyone has it in hand yet, but really it's only 10 slides, so it shouldn't take too long. I wanted to go over the affidavit absentee issue, which is centrally germane to much of the resolution. The first slide is affidavit, and I'm just providing the definition of affidavit as it exists in Black's law, which is clear that it's something that it needs to be confirmed by oath, sworn to or affirmed before an officer with authority to administer an oath, or taken before an officer having authority to administer such oath. In 1942, when the amendment was passed for absentee voting, the legislature itself also had similar definitions for what an oath was, and they had safeguards in place requiring that an affidavit with an absentee ballot be sworn. And so there was no question about what an affidavit was. Okay, so if anyone's not clear, that was 1942. And there were several safeguards that were put into place by the legislation at the time of the amendment. And at the time of the amendment is a really important concept for everyone to understand. What did they mean when they passed it? Well, we had statute that actually tells us what they meant. And those safeguards were really designed to make sure that, the Part 1, Article 11, which calls for an equal right to voting, that we didn't have different classes of voters that were similarly situated. So we don't want to have a polling place at a community center where everyone has to go in and every movement is controlled from the point that they're in line to, getting an ID, to a blank ballot, to the privacy booth, all the way through to when they insert it into a machine or put it into a ballot box. Okay, all those movements are controlled by statute, as opposed to the absentee process, which once somebody has a blank ballot, they can do anything they want with it. They can traffic it. They can be electioneered. They can pretty much have somebody else sign it for them because no one's checking. So there's quite a big distinction in the way people are treated. At that 1942, they recognized safeguards, needed to be very similar. And we just don't have that anymore. In 1979, it was thrown out. So I'm going to move on to, I think I just really said why affidavits are required. So further down in the presentation, I've provided for an RSA that we currently have on the books, 65717. And this is really where we are, telling the voter who has an absentee ballot what they have to do. They have to execute the affidavit, right? In 65930, we have a definition. Statutes have definitions. We have 65930 says that an affidavit must be sworn. Again, going back to just like Black's Law and what existed back in 1942, still currently on the books. We have to execute an affidavit, and we define that it's got to be done, in front of somebody who is qualified to administer an oath. So what happened? 1979. We passed, that's this one right here, it's gray. Okay, 1979, it appears that the legislature decided to cut off the part where the affidavit execution piece is required. And that's why we have this House resolution, okay? How can we possibly swear to something in front of someone who's qualified to administer an oath if it's not on the envelope? So believe it or not, I'm almost done. The 657-7, which is the affidavit envelope, is not an affidavit. It's an affidavit envelope. Legislature cannot just change a label of something and call it an affidavit because they want to, okay? It's a self-certification. It's meaningless, okay? I'm going to leave this slide because I think somebody else is going to speak to whether or not legislature can change the intent of the Constitution. So we can skip that, okay? And I'm going to briefly discuss another element of absentee ballot, the absentee ballot, which is, whether or not the legislature can simply add religious, employment, care of children in the infirmed, or whether as reasons for allowing somebody to have an absentee ballot. We are very explicit in Article 11, Part 1, Article 11. It's absent from the city or town which they are inhabitants. It's clearly a geographical issue. Where you live, if you're not there, you can have an absentee ballot. Or physical disability. That is defined back in 1942 as a doctor, a physician. They have to certify that you're actually physically disabled. When we add things, that's violating a maxim of law. The inclusion of one is to the exclusion of another. A certain designation of one person is an absolute exclusion of all others. Yet the legislature did it. Finally, my final remarks are, and I think it was briefly mentioned, and I agree with the gentleman that spoke before me, where he said that these moderators had they had uncertified absentee ballot envelopes, and the moderator is only allowed to remove the ballot from the envelope if he can show that it's been certified. None of these have been certified. I don't know how many were national, but I'm thinking statewide, and I'm thinking about prior elections where the rates of absentee balloting went way up. They skyrocketed to like 32%. How many of these have been certified and included in the ballot stream? Think about that. So just in closing, I would appreciate that this committee, if they're going to take up any rebuttals to anything that I put here, which has been submitted already to the record through the website, that you share any dialogue, and especially if you could do it in written format, I'd appreciate it, because I think that no one has been able to rebut any of this information to this point. And thank the Lord for having me here.
Thank you. Appreciate it. Are you open to taking questions if there are?
I am,
any?
yep, sure.
Do we have questions? We have one. Representative McCarter.
Thank you, Mr. Chair. Thanks for coming here today, sir, to address this House resolution. I understand there's a lot of conflicting opinion on it, but I can clearly see yours. A question for you was something you made me think about with regards to this presentation. It's obviously you've put some time into creating a PowerPoint about this. Have you approached the Secretary of State's office with regards to the information contained in this presentation?
Yeah, actually, I, along with a lot of others, served a lawful notice to the Secretary of State, and he took a meeting with us, and Representative Panic and two other representatives as well. So he's very aware of the issue, and I think he was made aware of the issue before. We just did a lawful notice, and we met with him in early December.
Has he responded in any way or rebutted the information in any regard?
Well, during the meeting, he debated a few of the points, and his response was that he thought that he believed that he was acting within the Constitution to the best of his ability. But we did ask him to put it in writing, and he said he could not. And he has been to this point unable to rebut anything we've said. Zero. He's provided, and he in fact sent me a letter saying that he wasn't going to, and I have a copy of that.
What's that? One more, last one.
So he did respond. I just want to make sure I understand what you just stated. He responded to you saying he wasn't going to acknowledge any of this, or what, can you explain that response a little bit more?
During our meeting, he responded orally to the notice, which we requested written, written point by point rebuttal. He did not. He responded to my affidavit that I sent to him that, detailed what happened during the meeting, saying that he was not going to take any further action.
Thank you. Any further questions? Rep. Sellers.
Thank you, Mr. Chair. Sorry I'm late to the party. I was at someplace else. But in any case, House resolution that we have before us right now that you're talking to, do you believe this will, if we could get it to pass, will it solve the problem? Or will we have to do something further to resolve this affidavit problem? Because I agree with you, in my town, we went from 50 absentee voters to 500 when COVID hit. And then that was just, to me, it was phenomenal. So I just want your opinion on that.
Well, my opinion is that a resolution is an acknowledgement of the notice that we're providing today. So I think that goes a long way in terms of, starting the process. Do I think it's going to resolve everything? No, I think it's a down payment. But certainly if there are things that can make some of these statutes, which are not, do not come before the Constitution, if they can make them acknowledged, they already are void, in my opinion, because they're repugnant to what the Constitution says. So it's more or less a formality at this point as to how the legislature follows through and makes that, generally accepted amongst the public in themselves. So if we've already gone to the executive branch and, they're ignoring us, the legislature ignores us, and, perhaps I heard mention that, there's a individual rights case on this issue with the Supreme Court. Okay, so that's all three branches of government. If we can't get this resolved, where are we? We're doing everything we can peacefully. All three branches of government are going to ignore it. We can't do that anymore. I'm afraid that there is actually an instruction in the Constitution as to what happens when all three branches of government ignore you. It's not a good result.
Thank you.
Any further questions? Seeing none, thank you for your testimony.
Thank you.
Still there. Yeah, we'll go here. Chair recognizes Andrew Noyes. 2 minutes in support of the bill. Welcome to Legislative Administration.
Thank you. Good morning. My name is Andrew Noyes. I am in support of this resolution. I'm one of the people coming of my own right. I'm not representing any firm or group. The input from the clerk was a bit telling, but frankly, I think that his statement actually contradicted itself. And that is the primary source of authority for everything that's going to be discussed in this room and here in this city is the Constitution. And so while Masons may state one way or another what should or should not be discussed when there's an individual rights case, the fact still stands that the Constitution says what it says and has said so for quite some time. And this resolution is simply calling the legislature back to that. And that is in Part 1, Article 11, and Part 2, Article 32. It's very plainly stated what the requirements are for a lawful election. And so whatever is debated here, it really doesn't matter if it doesn't comport to the Constitution. I think that we all would agree that if there was a matter before the courts about the constitutionality of murder, and there was murder happening out in those streets, that it wouldn't matter what the resolution did or didn't say. If it said the Constitution very plainly says that the people of New Hampshire have a right to life, then we have to go stop that. And whatever was granted to the legislature to make that happen needs to happen yesterday. Part 2, Article 32 very plainly states the requirements for human eyewitnesses to observe and count the votes. The leap from that to a machine, and one of the prior gentlemen went into detail about some of the inner workings of those machines. The leap to a complex machine is very far from the human eyewitnesses. And it's not the job of the legislature, it's not the job of any executive or judicial members to decide that that human eyewitness now means a machine. Frankly, I think it's kind of ridiculous, and I think that everybody in this room needs to remember that the testimony from the clerk earlier was referring to Mason's manual, which says that the Constitution stands on a higher plane, which of course comports with legislative procedure to consider the Constitution before anything else. And to ask this simple question, does Part 1, Article 11, and Part 2, Article 32, clearly state the human requirements for conducting an election? If so, the question has already been answered then. And the matters set forth in this resolution are really self-explanatory and need to be acted on immediately. That's all.
Thank you for your testimony. Would you be willing to take questions if there are any?
Yes.
Are there any? Rep. Pearson,
It's a two-parter because it requires a.
let's start with the first one.
Do you know where the largest polling place in the United States is? Single polling place? It's in Derry, my district. We have 18,935 registered voters. What happens if I can't get people to hand count my ballots? Are my constituents now not afforded their right to vote and have their vote counted?
Again, I think that the question is avoiding the initial imperative and obligation that you have as a representative to lawfully carry out elections. Though we are,
You're not answering my question. You're not answering my question.
I am answering your question though, because you swore an oath to the Constitution of the state of New Hampshire, which clearly states the requirements. Electronic voting machines are not those requirements. If we want to amend the Constitution, everybody in this room, I assume, knows the simple, lawful means to do that. But as it stands now, the Constitution plainly states how those are to be counted. So while we are all, of course, sympathetic to the fact that that might take more work, you have to figure that out. And you can discuss how you're going to have those double the amount of polling places, get more eyes on. They have to be human eyes. If you want to talk about the expediency of the process, that has to occur within the lawful constitutional bounds placed on you as a representative. So as far as whether those count, they must count. Again, Part 1, Article 11 clearly states that they have to be counted and that the people have a right to be represented through their vote. But as far as the burden on those workers in dairy, while sympathetic to it, you have to figure out how to do that in the lawful bounds set forth in the Constitution. So what happens, to answer it directly in a nutshell, what happens is you figure out how to count those votes by hand. And though it may take a long time, the representatives and the individual officers and clerks who swear an oath to do this job have to know that sometimes it's going to be hard work. That cannot ever trump what the Constitution says.
Thank you. Any other questions? Thanks for your testimony. Appreciate it. I see a similar name. Christopher Noyes? Similar town, similar amount of time. Call Christopher Noyes. 6. Welcome to Legislative
Mr. Chair.
Administration.
Thank you. Mr. Chair, question? Representative? He was asking if he could go last. Is that possible?
We have these laid out the way we're going. Thank you. Sorry about that. I didn't hear you. Did you ask me that? No, I did not hear that. Sorry. Mr. Noyes?
Yes. So my name is Chris Noyes. I am residing in Bethlehem, New Hampshire. And I'm just here as one of the people to speak to the issue. I support the bill. Essentially, let me back up and say that it's my understanding that a resolution operates similar to a bill. If it were to pass the House, it would need to pass the Senate, and the governor would have to sign off on it in order for it to be binding. But at that point, it is binding, every bit is binding as a bill. So these claims that the resolution is meaningless or non-binding or just a virtue signal, I don't see any written evidence of that anywhere. So I disagree with that. So I do believe that it's worth trying to walk through the process just like a bill. The reason why it's better than a bill is because bills add on layers of statutes to the fundamental law. And that is exactly what has gotten us into the jam we're in now. And so this resolution, rather than attempt to add more layers of peels to the onion, strips away all the statute which is in conflict currently with the existing articles of the Constitution. So the aspect of the human eyewitness has been brought up. And the reason why that's important is because if there's to be a challenge to the count in the election and somebody would like to take that to court, for instance, 2 or more eyewitnesses are required to establish a fact in law, and the machine precludes that ability for the humans to do that. So the founding generation, they understood law very well, and they understood that 2 or more eyewitnesses are required to establish a fact in law. So they placed the clerk, the moderator, and a select board witnessing with their own eyes the sorting and counting of the ballots. The benefit of that is, like I said, if there's a challenge to the vote, any one of those humans can be placed under penalty of perjury, put on the stand, and asked to testify. And they have the fear of the law in them to know that if they're caught lying, they could spend time in prison. A machine, though it may be able to count and sort as well as a human being, does not have the ability to get on a witness stand and testify to what it has seen, nor is it afraid of spending time in jail. I think that's pretty ludicrous, right? So the other aspect to this is that the legislature is not granted authority anywhere that I can find in Part 2 frame of government to amend or alter a constitutional provision. The only lawful way to amend or alter a constitutional provision is through Part 2, Article 100, at a biennial election where the proposal is made to the people and the majority of the people vote whether they agree or disagree with an alteration to the amendment. As it stands today, Part 2, Article 32, for instance, has never been amended by the people. So all alterations by legislature are unauthorized, null and void. As to the affidavits, that was covered briefly, and the part that I think I would like to fill in there is the very definition of an affidavit as seen in Black's Law Dictionary shows a sworn officer of the court verifying the identity of the voter, and also shows the sworn officer of the court verifying the identity of the person who comes before them. Well, the current situation with affidavits, because I was at that meeting with the Secretary of State, and I posed to him this understanding that the affidavit needs to be conducted in front of a sworn notary of the court. That's the whole point of it, is to verify the identity of the voter. And also the statute calls for them to witness the voter filling out the ballot. And the Secretary of State replied to me, well, the voter can sign on the affidavit themselves, self-certifying that they are who they say they are, and send it in. But that defies the very definition in Black's Law Dictionary, 4th edition, of what an affidavit is. So there's a clear deficiency there. Let's see. What else do I need to speak to? I had wanted to go last so I could kind of tie up any loose ends, but does anybody have any questions? Okay, well,
I don't know.
I'll speak to convenience. Like as Andrew Noyes said, my son, I'm very proud of him. As he so aptly stated, convenience cannot be a consideration when each one of you already promised in advance by way of oath. Part 2, Article 84 says you accepted the trust. And the New Hampshire Constitution is a trust indenture. We are the grantors, you are the trustees. You already promised us that you would fulfill the contractual terms. I'm not sure if you're all aware that it's an actual contract. Like in Vermont, Part 1, Article 6 actually says all government agents are the people's trustees and accountable to them in a legal way. So you already promised to us contractually that you would fulfill the exact terms of the contract. Now, in an express trust contract, only what is expressly written is authorized or granted authority. And what is not as expressly written is not authorized. For example, let's say I have a trust fund and I invite you to be one of my trustees to identify cash flowing real estate properties, and I offer you $2,000 compensation for each one you find, and you agree to be one of my trustees and you come into contract with me. One day a month down the road, we're having coffee and you show up in a Ferrari and I say, that's a beautiful car, where'd you get the money? And you say, well, I bought it with the trust fund money, helps me get to the real estate properties to buy them quicker for you. And I say, well, where does it say in the trust that you could do that? And you said, if you replied to me, it doesn't say I couldn't do it. I think you can see we'd have a problem, and that in court of law, you would be held responsible for your fiduciary duty. Well, in New Hampshire Constitution, Part 232, it shows 3 human beings sorting and counting the votes. And it doesn't say anywhere in there that you can add in a monkey counting them on the moon. You can no more add a monkey counting them on the moon than you can add a machine. You don't have that authority. So all along, this whole time, the machines have been unauthorized. You promised us that you would do it exactly the way it says in Part 2, Article 32. And this resolution would strip away those statutes which you were unauthorized to make, bring us back to the original operating principle where we would have our eyewitnesses if we need them to testify in court to any miscount or tomfoolery. And as far as the convenience factor, as Representative McCarter has said, that's actually the job of the legislature, is to figure out that type of detail. And you can write statute for how many polling stations you would be. I mean, a very practical solution would be to double the amount of polling stations and have enough workers in there to count the votes. So you could take that 18,000, however many votes are counted in each one, you could take that down. That's just a practical, I'm not saying that is the solution, but I think it's just to show that it'd be pretty easy to probably come up with a solution. But once again, convenience can never be used as an excuse to not follow the law that you already promised to follow.
Thank you.
Thank you.
We're proud of your son as well.
Mr. Chair, I just want a point of clarification here, because it's now been stated 3 times that statements are being made that this is like a bill. And this is a non-actionable House resolution. And I think we're getting away from that clear fact.
Understood. Thank you. Chair recognizes Daniel Richard. Indicates 10 minutes. Be nice if it was less than that. Supports the bill and has written testimony.
I have.
Welcome, Mr. Richard.
Thank you, ladies and gentlemen of the committee. It's my honor to be here today. My name is Daniel Richard. I'm a citizen of New Hampshire. I'm representing myself and I'm for this bill or this resolution. What I'd like to speak to today is something different than what everyone else has talked about. So let me begin with, I'm a constitutional scholar, and I'm here today to share with this committee the relevant and recent decisions of the state Supreme Court and the Supreme Court of the United States, and how these cases will affect this legislature moving forward. I believe the subject matter raised by the recent court rulings are not only important because they affect the making of law by this legislature over those specific subjects, but also because it affects the way the legislature must act in the future in all legislative matters. Those cases include the New Hampshire Supreme Court recently decided in Brown versus Secretary of State over the redistricting fight, which cites the recent Supreme Court decision in Moore v. Harper decided in June of this year. And that's really the heart of what I want to get into because it has a dramatic effect on all 50 states. And it was over the redistricting conflict. Moore v. Harper is not just about how election laws must be written, but Moore v. Harper also addresses the rules now controlling judicial review by the state and federal courts, which now affects all 50 states. The other recent cases are the two federal Second Amendment cases, the District of Columbia versus Heller and New York State Rifle and Pistol Association versus Bruin in 2002. Both cases have corrected the standard of review, which now must be used in all the courts, including the state legislature. When all of your federal protected rights are implicated, the plain text, and that's what this court, the Second Amendment cases were all about, is as soon as the plain text of any legislative act that you go to move forward, if it implicates any one of your enumerated federal rights, you now have to prove, the burden of proof shifts to the government. And that's a radical departure from past standards of review where the moving party would have to prove standing in the court. And so that deals specifically, those cases dealt specifically with the Second Amendment. But what happened in Bruin, what happened in the Bruin decision is that the court, because the lower courts were not getting the Second Amendment case from DC correct, they were not applying the proper standard of review. Heller clarified it. Heller went on to say that any time you're dealing with any one of your federally protected rights, that's any of them, that this standard of review now applies. So this is important from a legislative perspective, and within the body of this committee, you now have oversight as to how this body functions, how the legislature functions. So that's why I wanted to bring these things to your attention. Okay. I want to get into quotes from the court to deal with this subject matter. And the first one is the Second Amendment case, where reaffirming what I just said to you about the standard of review applying to all the cases. This is Justice John Roberts, I believe. We reiterate that the standard for applying the Second Amendment is as follows. When the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. The government must then justify its regulation by demonstrating that it's consistent with the nation's historical tradition of firearms regulation. Only then may the court conclude that the individual conduct falls outside of the Second Amendment, its unqualified command. And again, this was reiterated in Bruin, citing Heller. The Second Amendment standard also, and this is where it applies to all of your rights. The Second Amendment the Second Amendment standard accords with how we protect other constitutional rights. Take, for instance, the freedom of speech in the First Amendment, to which Heller repeatedly compared to the right to keep and bear arms. In that context, quote, when the government restricts speech, the government bears the burden of approving the constitutionality of its actions. And again, this committee having oversight over how this legislature functions, I felt this was pertinent for you to understand. Moore v. Harper, on the other hand, is the redistricting fight that came down 6 months ago approximately. Moore v. Harper explores the meaning of the election clause, the federal election clause. Article 1, Section 4, Clause 1 of the federal Constitution requires the legislature of each state to prescribe the rules governing federal elections. The election clause of the federal Constitution, Article 1, Section 4, Clause 1, is a fundamental right of the people and is expressly requires of the New Hampshire legislature that it shall prescribe the times, places, and manner. And manner is key. That is the process. And that's what this is now affecting. It's now going to affect how the legislature must deal with legislation, with the restrictions that are now part of this court. So let me continue. Because of this, This power is specific and it's mandatory. It cannot be delegated. The legislature cannot delegate its authority to make law, for example, to the Ballot Law Commission. This is a big problem. The New Hampshire Supreme Court, in its recent decision in Brown versus Secretary of State in New Hampshire redistricting case, cites the North Carolina redistricting case Moore v. Harper. And in that decision, Justice Donovan recently wrote, citing Moore v. Harper, explaining, in congressional redistricting case, the Supreme Court has an obligation to ensure state court interpretations of state law do not evade federal law. And again, that was just recently cited by the state Supreme Court, making Moore v. Harper now state precedent, in my opinion. The argument advanced, moving on to the court's opinion on the subject. Nothing in the election clause instructs, nor has this court ever held, that the state legislature may prescribe regulations on the time, place, and manner holding federal elections in defiance of provisions of the state constitution. That's critical. They're making the point that the state legislature is bound by its written document. And he goes on to say, quote, the argument advanced by the defendants in this case and the dissent also does not account for the framers' understanding that when the legislature makes laws, they are bound by the provisions of the very document that give them life. Legislatures, as the framers recognized, quote, are mere creatures of the state constitutions, and they cannot be greater than their creators. What are legislatures? Creatures of the Constitution. They owe their existence to the Constitution, and they derive their powers from the Constitution. It is their commission, and therefore all acts must be conformable to it, or else they'll be void. Marbury confirmed this understanding, and nothing in the text of the election clause undermines it. When a state legislature carries out its constitutional power to prescribe rules regulating federal elections, the commission under which it exercises authority is twofold. Citing Federalist number 78, the legislature acts as both a lawmaking body created and bound by its state constitution and as an entity assigned particular authority of the federal constitution. Both constitutions control and restrain the legislature's exercise of power. And finally, the last couple of points here. The dissent, back to the Supreme Court here. Arizona, just as a sidebar, Arizona in a few years back decided to take from the Arizona legislature the ability to redistrict because Arizona's constitution, just like ours in Article 26 and Article 65 of Part 2, clearly established, and that's what the state Supreme Court just reaffirmed a month ago, that because the Constitution prescribes that the state legislature is responsible for redistricting, the courts have no business telling the legislature what to do. So in that case, they also expounded on Arizona. Arizona amended its constitution properly and created a redistricting commission. It's got problems. They were already suing each other. The legislature is suing the redistricting commission. You already have that as a proposed CACR before the body now. I think it's CACR 19. But making the final points here on this, on that issue, Arizona state legislature, the dissent reads Smiley and the Arizona state legislature in a different light. Justice Thomas thinks those cases say nothing about whether a state can impose substantive limits on the legislature's exercise of power under the election clause. But in Smiley, we addressed whether the conditions which attach to the making of state laws apply to the legislature's exercise of authority under the election clause. We held they do. Much that is urged in argument with regard to the meaning of the term legislature, we explained, is beside the point. And we concluded in straightforward terms, the legislature must abide by the restrictions imposed by the state constitutions. And when exercising the lawmaking power under the election clause, citing the Arizona state legislature, said much the same, emphasizing that by this text, nothing in the election clause offers the state legislature's carte blanche to act in defiance of the state constitution. And I'll move to the state constitution, Part 2, Article 5, the very instrument that gives you your authority. Very old case, still stands today, Merrill versus Sherburne, 1818, which said the following: that clause, which is referring to Part 2, Article 5, which confers upon the general court the authority to make laws, provides at the same time they must not be repugnant or contrary to the Constitution. So, my closing points are, we have a big problem now. The Ballot Law Commission, under these precedents, the Ballot Law Commission no longer has authority to authorize the towns to use voting machines, which is now illegal Not because I say so, it's because the New Hampshire Supreme Court has just incorporated Moore v. Harper, where this is argued before the federal Supreme Court. And finally, I'm the one bringing the action before the court now over many of these illegal changes to our election laws that I believe are unconstitutional. But let me quote Justice McDonald, who, if you want to balance where you think this case is at, please go see the oral arguments. You're going to see that the state did not do a very good job defending itself. And Gordon McDonald, Chief Justice McDonald, said a brilliant question. He posed this question, and this is what I want you to remember. Quote, permissible legislative judgment. He's asking the state's attorney this. Permissible legislative judgment. I don't understand what that term means. How is it permissible legislative judgment permissible if it exceeds the authority of the Constitution? Brilliant. They were prepared. Thank you. Questions?
I don't know. Are there questions? Representative McCarter.
Thank you, Mr. Richards, for coming today and speaking on this House resolution. There's a state that's a neighboring state of ours, Massachusetts, has a very similar constitution. In your experience, I understand that you're a very studied man with regards to the New Hampshire Constitution. Are you aware of the similarities to our Constitution as Massachusetts has, and how they have voting machines in Massachusetts? Could you speak to that, or no?
Yeah, absolutely. Really straightforward. John Adams wrote the Massachusetts Constitution in 1780. New Hampshire was actually the first of all 13 colonies to write a constitution, but it was very defective. There was one chamber. So we go through the Revolutionary War. On the other side, New Hampshire had the great fortune to look at the other 12 that had gone into effect during the Revolution and wrote our Constitution predicated on theirs. The courts always look with great interest over opinions or changes to the function of sister states, next door especially, because of that genealogy. And in this case, Massachusetts had the same provision about Part 2, Article 32, that requires 3 human beings to conduct the election process. The moderator is supposed to sort and count the vote. He's supposed to examine the ballots and declare the count. How can he declare the count if he actually didn't count the ballots? The clerk has a duty to not conduct his own certification or his own count, but rather to witness the process and then certify that he witnessed the moderator sort and count the vote. And remember, there was no electricity in 1784. The courts are very clear on this. You're not going to get a court anywhere in the 50 states to say anything other than when we look at anything to do with our state or federal constitutions, we look at original intent. What did they mean? And so back to the answer, Massachusetts put it on the ballot. They put it on a referendum. And that's what I advocate here. You know, the beauty and the genius of our form of government is the ability to alter it. And I got to tell you, I'm an independent. I vote Republican, but I'll tell you this, the Democrats are smart about some things, okay? And one of them is they hire good lawyers. And what are they all doing about the lack of progress they're making over issues? The redistricting fight. What did they do there? They lost twice. It was vetoed. So now they're putting a CACR. Abortion is another great issue, right? Why did it get struck down? It's because it wasn't a constitutional right. So now what are they doing? They're preparing a constitutional amendment. And so to all the grievances that I am against in my brief, in my lawsuit, is all the same problem. It's all failure to follow the process because we're guaranteed a process. Hope that answered your question.
Thank you.
It's just based on what you just said. It just helped me out here that the moderator is required to count the ballots.
Sort and count. Sort specifically is what's not happening.
The moderator, that's a singular person?
That's right.
Okay. All right. I'll just go back to my 18,935 people being counted by one moderator.
That. Let me give you a really good solution if you like. I'd like to answer his question if that's okay. Here's the simplicity of it. The Constitution of New Hampshire was written in 1784 with a population which is much smaller. And so it's been amended a bunch of times along the way. And the proper process at each step. So the solution to your problem is we need to have some type of amendment to address the issue. Like one of the other gentlemen pointed out, if the legislature needs to pass legislation to reinforce the local municipalities to deal with this, look, this legislature is going to have to deal with this problem if it rules and strikes these things down real soon. like sooner than later, maybe before the upcoming election. And if they don't have machines in place and the court strikes that down, they need to put a game plan together, and better to know now than to find out during the election process. But that's what you need. You need an amendment, either a legislative act that calls more people to serve, or put an amendment on the ballot measure forward in order to create or authorize the use of machines.
Thank you. You mentioned you had written testimony?
I did, and I've submitted a copy.
We do have it. I apologize. Thank you for your testimony.
Thank you.
Appreciate it. Chair will call Tricia, I'm going to murder this name, I'm sure. Tricia Nuwala. Welcome to Legislative Administration. You indicate you're representing yourself and supporting the bill and asking for 3 minutes.
Yes, that's correct.
How'd I do in the name?
It's,
No, yeah, I thought so.
it's okay. I answer to
Welcome.
most things.
Could you introduce yourself and that you support the bill and where you're from?
Good morning, House Committee. My name is Tricia Navalu. I am representing myself and my community. I'm from Stratham, New Hampshire. And I wanted to support this because throughout my career, I have used an alias. And in fact, most of the community I work with uses another name for safety precautions. I am the founder of Erotic Laborers Alliance of New England. We offer resources to consensual adults engaged in sex work, and we are an anti-trafficking group. Granting immunity when giving testimony for certain community members would increase their sense of safety, and it would encourage more testimony of their lived experience. Oh,
I'm sorry, that may be my fault. Is there
Oh, I put it under here, sorry.
the card? I assumed.
did I fill it out wrong?
No, I did. I read it wrong. You are here talking about 1367.
1367, correct.
Okay. We're still in the hearing for House Resolution 25.
Sorry.
My fault.
I just
Nice meeting you.
Nice
Um,
meeting you.
We'll be back.
I'll be back.
Thank
okay,
you.
good. It was like a practice run.
It's an imperfect committee, I should say. With that, we'll move to Rep. Potenza. 2 minutes you've asked for. Welcome back.
Thank you. Sorry, computer won't open. Thank you, Mr. Chair. My name is Representative Kelly Potenza, Stratford District 19, which is Rochester wards 1, 2, 3, 4, and 6. I'm here to speak in fully support of House Resolution 25. I support this bill because I know that there is really only one lawful way for any constitutional provision to be altered, and that is by asking the people in a biennial election year if a majority of them agree to amend the Constitution. It's pretty simple. Other than that, the legislature does not have any authority to amend or alter a constitutional provision. I have searched repeatedly, and I cannot find any record of the people of New Hampshire voting to amend New Hampshire Constitution Part 1, Article 11, nor Part 2, Article 32. Despite this lack of evidence showing that the people who are the only ones with the authority to amend a constitutional provision, I do in fact see that New Hampshire Part 1, Article 11, and New Hampshire Part 2, Article 32, have been altered by the legislature via statute. These unlawful acts must be reversed. I'm going to digress just real quick because of all this testimony that's happened. I don't understand how do we pass a bill, because this is a resolution, right? So we're out of compliance. So if we're out of compliance, we're breaking the law. So how are we going to pass a bill to say don't break the law? So then maybe we should just pass a bill that says that. So that, to me, is just like a circular firing squad, but I digress. So we must now resolve as a body who are bound by oath to uphold New Hampshire Part 1, Article 11, and New Hampshire Part 2, Article 32, to fulfill our fiduciary duty to uphold the constitutional provisions as they appear expressly written now in our state constitution, which is a trust indenture contract, which is mentioned, of course, in this resolution. Voters are the grantors. I, as an elected official, I'm the grantee in a sense. The voters are their trustees. I, as an elected official, am responsibility for protecting the trust, the contract. In essence, the representatives are the employees to the citizens of New Hampshire. Unless anyone on this committee or anywhere else in this, legislative body possesses evidence that there was in fact a vote by the people to amend the constitutional provisions as seen in New Hampshire Part 1, Article 11, and New Hampshire Part 2, Article 32, then I need to see that evidence, and it needs to be placed into the express writings of those provisions. Because as it stands today, the express written provisions do not make allowance for any machines. And machines have been talked about a lot. And I'd really like to focus on the absentee ballot piece, because that is the huge one that has changed since 2020 moving forward by percentage increases. In a town at the time I was living in Rye, the absentee ballot rate was less than 10%. It went up to over 30%. We had over 100% voter turnout. That can't be when it's never been more than 65%. These are the things that, to me, the absentee ballot process, which in the Constitution, the only two ways that you can vote, if you are absent from the city or town of which you are inhabitant, or by reason of physical disability and are unable to vote in person. That to me is so crucial, and I don't know if that's really been talked about a lot today. So, where am I at? So for these reasons, HR 25 in necessity in order for the legislature to provide a path to come back into compliance with constitutional provisions controlling the parameters of elections in New Hampshire. I hope that you take. I'm glad that you gave us all this time. I appreciate all the thoughtful questions, and that's it.
Thank you for your testimony. Are there any questions? Seeing none, thank you very much. Appreciate you hanging around. Last pink card I have is for Brian Gould, indicating he's speaking for himself and asking for 5 minutes and is opposed to the bill. Welcome, Mr. Gould.
Sorry, that's better. Thank you, Mr. Chairman, members of the committee. My name is Brian Gould. I'm a lawyer here in Concord. I practice with Cleveland Waters and Bass, 2 streets over. I practiced law in New Hampshire about 35 years. Over the course of my career, I've regularly litigated constitutional matters, which is unusual because I'm a civil litigator, not a criminal litigator. They deal with constitutional issues frequently, but in the civil context, not quite as much. To give you a couple of quick examples, I was the lawyer for the governor and executive council when the legislature attempted to modify the statute that would dictate who the Chief Justice of the Supreme Court would be. And we prevailed on an original petition before replacement justices on the New Hampshire Supreme Court, because they were all recused because it affected all of them. But we prevailed in that case, and the reconstituted court held that that the legislature had violated the separation of powers and had violated the Constitution by attempting to intervene in how the Chief Justice was selected. Another case in which I worked was more recently was the Senate Bill 3 litigation. I know the chairman is very familiar with that because I believe he delivered the committee report on the floor for the Election Law Committee supporting that bill. I was retained by the state of New Hampshire to supplement the the defense of that bill by the Attorney General's office. I represented the Attorney General, who at that time was Gordon MacDonald, and the Secretary of State, who at that time was Bill Gardner, in that case. And we tried that case, and eventually it was taken up to the New Hampshire Supreme Court, and the bill was struck down. The reason I mention this is because over the years, I've developed a fair amount of experience with election law. I'm not at the level that, say, Bud Fitch is. You know, Bud is sort of encyclopedic on those things over at the Secretary's office. But I have had a fair amount of dealing with these cases. Those of us, and I count myself among them, who favor increasing the integrity of our elections, have to face some facts, though, because these issues end up getting resolved in the courts. And so it's not a matter of theory, it's a matter of experience. What have we learned from the courts in New Hampshire over the years? One thing that we can say with some certainty is that the courts look very skeptically on changes in law that restrict ballot access from what it is currently. So you start at a disadvantage to the extent that you're trying to cut back on ballot access. And that is sort of an overarching principle here is, if you think about it, there's tension between the desire to ensure that only qualified voters can pull a ballot and the burden that's placed on voters, their right to vote. Because if you are going to restrict access, you're going to say, I'm going to impose these qualifications. You are necessarily excluding some voters as unqualified. And the question becomes, is that necessary to protect against unqualified voters voting? And that's the balancing that the courts undertake. Another observation is, and this is why I decided to come today, because it's not so much the underlying policy that's being promoted by this, but the vehicle by which this is being proposed. Because aside from the language of any amendment to the RSAs, probably in an election law case, probably the most important factor is whether the new restriction, the most important factor in determining whether the new restriction survives judicial scrutiny is legislative history. If any inflammatory or eccentric language in legislative statements, not that that would ever happen, but whether it's in the bill, in committee, on the floor, make the defense of the new language very difficult. As an example, in the Senate Bill 3 case, the plaintiffs, who were the Democratic Party and a national super PAC, had become involved and recruited some plaintiffs. But they focused on the fact that some people, even just lobbyists, had testified that the reason for this bill was to prevent college students from voting in New Hampshire elections. And the bill did nothing of the kind. But because that was in the legislative history and showed a certain hostility to a certain class of voter, the Superior Court seized on that as evidence that this bill was intended to restrict votes without an appropriate basis. And I know that House Resolution 25 doesn't actually amend anything, although it sounds like there's some debate about that. But if it were to pass and legislation were actually enacted, that is consistent with the objectives of House Resolution 25, the resolution itself will be part of that legislative record if the bill is challenged on in the courts. And I believe that several parts of this resolution will make future consistent amendments to the statutes, that is, regarding absentee ballots and voting machines, far more difficult for the Attorney General's office to defend. For example, you heard a reference to the Constitution as being a trust instrument. There is one reference to trust in Part 2, I think it's Article 84 of the Constitution, but the Constitution doesn't itself say that it is a trust instrument. So the reasoning that flows from that assertion in this resolution would be viewed, I think, as it's interesting intellectually, but I think the courts would view it as an eccentric point of view, which harms your ability to defend the legislation. This resolution relies on 16th century maxims of law from Lord Coke and Sir Francis Bacon, both of whom were controversial in their time. This was before the Pilgrims sailed for the New World, that they were positing these maxims under English law. I can honestly say I've never seen the New Hampshire Supreme Court cite one of these maxims. They may have at some point, but it's not likely to be very persuasive at all. And to include something that is that unusual in the legislative findings and recitations makes it very difficult to defend the merits of any change in the law that you might enact. Mr. Richard testified about his understanding of the Bruin decision, and I understand what he's trying to say about that, but I think what he's, and the reason it's important is it's in the resolution. That's a very aggressive reading of Bruin, that it now eliminates the means ends testing. You may have heard of strict scrutiny, intermediate scrutiny, rational basis tests. These are all tests the courts use to determine whether a burden on a constitutional right is lawful. And the court did express skepticism about that in Bruin, but that case is limited to the Second Amendment. The court has not said that it's dispensing with that altogether. So for this legislature to accept that reading of Bruin before the Supreme Court has said that it applies across the board, and before the New Hampshire Supreme Court has said anything about whether it will follow Bruin for matters of state constitutional rights, again, undermines the legislature's credibility with the courts. And it's very important, if you're going to undertake these kind of policy changes in the election law context, that you have that level of credibility. There are citations to a number of authorities in this resolution, none of them to an opinion of the New Hampshire Supreme Court justices or an opinion of the New Hampshire Supreme Court itself. And in fact, that's important because during the Civil War, our court, the justices took up a statutory change to allow the men who were fighting for us in the Civil War to vote remotely. And our Supreme, which all of us I think would be generally sympathetic to, Supreme Court said no. The Constitution at that time did not allow for absentee balloting of this kind, and they didn't allow it. And there was, a few years later, there was a fix that did get past the court. But my point is, there is New Hampshire authority, but that's not cited in this resolution, which is a red flag to a court that, you know, you're not even relying on established New Hampshire law as the basis for this resolution. And then finally, there's a reference in here to the people having what's called in personam jurisdiction over legislators. Again, a very eccentric way of putting the concept that the legislature is generally answerable to the people. To courts, in personam jurisdiction refers to the ability of the court to exercise authority over a party before it. So to use that term in this context is jarring. And so my point in all of this is, I'm not here to talk about, you know, whether voting machines are a good idea or a bad idea, or you know, the scope of absentee balloting, although I think the New Hampshire Supreme Court and the justices have made pretty clear what the law on that is. But it is critical if you're going to go down this path that whatever it is that you pass is credible with the courts, because that's where it's going to end up. And so if you care about the outcome, any of these references to obscure areas of law and this sort of theorizing should be very, very carefully vetted, because you don't want to pass something that the courts read and say, I don't even know what this means. None of this language makes sense to me. I can't relate to it. It's not something on which I would rely. So that's my testimony. Thank you very much for listening.
Thank you for your time. Appreciate it. Would you be willing to take a question or two?
Oh, sure.
Are there questions? I thought there might. Representative McCarter.
Thank you, Mr. Chair.
Good
Thanks
to
for
see you
coming
again.
You too. Thanks for coming today.
You bet.
I just have a quick question, and I would suspect you have the answer. Can you point me to where I can find in our Constitution where we have to wait as legislators, or the legislature as a whole, where we would have to wait for the courts to point out that we have created statute in error, or we have made a mistake and we need to fix that mistake? Can you define that for me? Because I'm having a hard time with that.
If that's the impression I left you with, then that's my error. I did not mean to imply that you have to wait for the courts. What I'm saying is that if you modify statutes, the predicate on which you modify those statutes will be relevant to a review by the courts of whether that change in law is lawful. The legislature has independent authority to determine whether a statute is unlawful or unconstitutional in the first place. It can certainly do that. But if the result of that determination is that you're going to restrict access to the ballot, that raises a significant issue in the minds of the courts. We have a lot of indications, most recently probably in the Senate Bill 3 decision, but based on the Guer decision, that the courts are going to look very carefully at a change in law that makes it harder to get a ballot. That doesn't mean it won't uphold it, but you have to understand you're going into those cases with the court being very skeptical. And that's the battle that I'm trying to point out to this committee is the one you need to think about winning, because you can pass anything, but the courts have the authority to declare what you pass unconstitutional. And to get past that, I think you need to build a sort of a better record than I think this resolution does. Hope that answers your question.
Can I just follow on that point a bit? Is it the fact of being a resolution that the court would question, or does that matter?
I don't think it matters. I mean, I'm not going to jump into the debate over whether a resolution is effective. I think Representative Pearson made the point that that it is a resolution and therefore is not binding law. I think that's my understanding of a resolution. I'm thinking longer term, because if the legislature wants to change these policies on voting machines and absentee ballots, it's going to have to enact legislation to change the law. This resolution, containing as it does a certain rationale for that, becomes evidence when that later bill is challenged, because it's part of, I've heard people say this resolution sort of sets the table for legislation. If that's true, then that means if there's a challenge to it, this resolution becomes part of the legislative record. And if there's something in the legislative record that makes the courts look askance at what the legislature was thinking, that makes it much more difficult to defend the lawfulness of that later legislation. So that the short answer is no. The fact that it's a resolution doesn't matter. It's the content.
Thank you. Representative Sellers.
Thank you, Mr. Chair. Thank you for taking my question. I'm trying to understand something you're saying there, that how does this resolution exclude voters or restrict the ballot access if it's requiring the government to follow the Constitution.
And I understand, and I'm very sympathetic personally to that. What I'm trying to get across is this. The challenge to laws that restrict access to the ballot are evaluated against what is the current state of the law. So even if you've gone beyond what the Constitution requires, and so you're passing a law that you think brings it back within constitutional boundaries, you're still restricting access to the ballot from what it was, right? That's the whole point. And what I'm trying to say is when the legislature tries to restrict access, the courts look skeptically at that. It doesn't mean that the court won't uphold it, but the court looks skeptically at the legislature trying to restrict access. Because remember, I talked about there's a balance between the right to vote and this legislature's absolutely legitimate interest, which I defended at length and almost get to the point where I was out of breath in the Senate Bill 3 case. I'm very sympathetic to that. But those two things are in tension. And when push comes to shove, the courts tend to favor the access to the ballot piece. So I just want you to understand what I'm suggesting is that the fact that you're trying to bring it back into balance with what the Constitution requires, that's a legitimate thing to do. But understand that when you're cutting back on sort of the liberality of access to the ballot, the courts are skeptical of that. And you have to take that into account in what you put in the record to justify that change.
Anyone else? Rep. McCarty.
Thank you, Mr. Chair. So are you suggesting that we need to be, as legislators, we need to be mindful of a perceived opposition from courts when we're looking to institute legislation or get statute through that would be 100% constitutionally afforded ballot access? Are you suggesting that because it might be viewed as whatever the term of the day is, voter disenfranchisement or restricting ballot access, that needs to be a consideration when we're putting forth election law type proposals, that we need to look at how a court's going to view this, not how the Constitution does? Are you saying that those need to be weighted evenly, one more than the other? Can you elaborate a little bit on that, please?
If you accept the proposition that there can be disagreement over whether a law is constitutional, I think we can all agree on that there can be disagreement, then you have to be concerned, because the courts have the last word on constitutionality, at least under our current system. You have to be concerned that what you pass, as sincerely as you believe it's required by the Constitution, if a majority of the Supreme Court disagrees with you, then as a legal matter, you were wrong and the Constitution doesn't provide as you thought it did. And what I'm suggesting is this is a matter of wisdom. This is a matter of building the record so that whatever decision you make, and I honestly agree with you that absentee balloting got out of control in the during COVID and so forth. I think it needs to be dialed back. But what I'm saying is build a record that makes that decision defensible in the courts. It's not because it's my personal preference that you satisfy the courts. It's the recognition that the courts are going to determine, if there's a lawsuit, whether that change is constitutional. So the smart thing to do is to build the legislative record so that that is a defensible decision. That's all I'm getting at.
Further questions? I have one. And I'll preface it by saying I didn't fully understand this. So the Bruin level of scrutiny handled, mentioned under Bruin.
Mhm.
It was said to me earlier in testimony, or it was said to us earlier in testimony, that because of Bruin, the other three methods or levels of scrutiny seem to be washed away by Bruin. Can you elaborate on, or do you concur? Do you disagree? Do you, I think I heard you say that Bruin was specific to Second Amendment.
It was.
But
It
it
was.
sounded to me like the prior testimony was that it was now going to be something that the legislature had to take into account, this new level rather than the prior three levels.
Well, if it's a Second Amendment regulation, you would have to take it into account. What Bruin's, I've never liked the different levels of scrutiny, and Justice Thomas's opinion in Bruin really explained why. He said, you know, at least in the Second Amendment context, what we're doing is yielding power to the courts to make policy decisions. If we allow the courts to say, is this an important policy and are the means that you chose necessary or rationally related to that purpose, you can see how that shifts a lot of power to the courts. And Thomas gave that idea the back of his hand in Bruin and said, at least in the Second Amendment context, what we're going to focus on is the right that's at issue, in this case, carrying a handgun in New York City. Is that right consistent with the Second Amendment when it was adopted? And the court said it was. Clearly, that people were allowed to carry their weapons in public. What the lower court did is it said, okay, now that we've determined that, we're going to determine whether this restriction is necessary to achieve this state policy. And the Supreme Court said, no, you're not going to do that. All you're going to do is look at whether that proposed restriction is consistent with the kinds of restrictions that were in place when the Second Amendment was adopted. And if it is inconsistent, then it's unconstitutional. So Bruin made Second Amendment law very simple. Bruin did not revoke this means ends test, you know, strict scrutiny, intermediate scrutiny, and rational basis across the board. A lot of conservatives have sort of jumped on it and said, oh, this signals that the court's abandoning that. That's not the way lawyers look at things until the Supreme Court says, and by the way, we're doing away with all these means ends testing. We assume that it's still in place. More importantly, under the New Hampshire Constitution, our Supreme Court uses means ends testing. So unless the issue is an issue of federal law, and this would be under the state constitution, which is being argued here, the means ends test is still in place in New Hampshire. There's nothing about Bruin that changes that for a question of state law. I don't know if I cleared it up or made it worse.
I'll have to get back to you on that.
I'm sorry.
I appreciate the answer, however. Are there any further questions? Rep. Sellers, yeah.
Thank you, Mr. Chair. And I'll admit this stuff gets pretty deep, and I'm no expert on it, but questions come to mind and thoughts and stuff. And you know, didn't in the New Hampshire Supreme Court, Worcester, I think Worcester versus Plymouth, call the people grantors, and therefore aren't they the ones that create trust? I mean, if it's already been stated that we're the grantors, and the grantors, we're the ones that create a trust, isn't that correct?
Well, to some extent, it's just a question of terminology, right? Because there's no question, but from the earliest articles in the Constitution, that the authority of the legislature comes from the people through their consent. So that's really indisputable. What I'm saying is that the Constitution does not refer to itself as a trust instrument. There is one reference in the oath section, which is Part 2, Article 84, to whether an officer, I think believe the language is, accepts the trust as a result of being elected. But to extrapolate from that to the entire Constitution as a trust instrument, understand that my point is not, is it in fact a trust instrument? My point is, how do the courts look at that? Do the courts look at that and say, that's a very eccentric view of the law. That is not that's not the way we normally think about this. So just be aware that if you choose to go down that path, have a lawyer look at it and determine whether this is actually language that's consistent with the way the courts think about this stuff. Because if you don't do that, then when it lands on a judge's desk, the judge says, I've never understood this to be a trust.
Okay, I lied. It wasn't the last question. How,
Are my 5 minutes up?
yeah, well, that was 5 minutes of testimony. The questions don't add
Oh, I
into
see.
the 5
Okay.
minutes. My question is, and I'm not going to lose the opportunity to ask, my question is how this could have been done differently, or could it have been done differently as requesting an opinion of the justices prior?
Yes.
Could you comment on that?
Yeah, and that's the mechanism, of course, under our Constitution for determining whether a statute proposed or existing, particularly in connection with legislation that would purport to change it, you could send it to the Supreme Court and say, give us an opinion, an advisory opinion, as to whether this law exceeds the authority granted to the legislature under the Constitution. That's the straightforward way of doing it, and you avoid all of the. I mean, it's a much quicker way of getting an answer, and you don't take the risk that you do with passing something that's as sort of arcane as this resolution. Run it through the Superior Court, then up to the Supreme Court. You have a quicker answer, and that is the way the Constitution contemplates that these kinds of issues would be presented to the court.
Thank you. I think that it does answer my question, but I have to think that through too. Anyone else? Yes. No, that's fine.
So, thank you again for
I'm just
coming.
glad I piqued your interest in it.
You have a lot of information in your noggin that I probably could afford to learn from. Are you saying that if we were to send for this House resolution to the New Hampshire Supreme Court and ask for an advisory opinion, that would be a prudent thing to do?
No.
Okay.
I'm saying I don't think
Thank you.
I don't think this resolution is a good idea. I think if you want to accomplish the underlying policy goals, that is restricting absentee balloting and restricting access to machines, you ought to maybe amend this somehow or put forward legislation that does that and ask the court whether existing law, whether this bill is consistent, the proposed bill is consistent with the Constitution, and whether existing law is consistent with the Constitution. That's what I'm saying.
See, that I'm glad you asked that question. Thank you. I appreciate it. I think we appreciate your testimony. I have no further pink cards, right?
I think we're good.
For the right bill. I have no other pink cards. I'll close the hearing on House Resolution 25. It is almost perfectly the right timing. What I would like to do, I've closed the hearing on HR 25. I would like to open House Bill 1367 and recess it to a time certain, or move it to a time certain. That would be going to 2 o'clock. And the reason for that is the prime sponsor of that bill, as well as the bill that's due for 140, happens to be the same time. What's that? Yeah. Then the House Bill 1219 will be rescheduled to January 31st, a hearing that has yet to been put into the calendar. And then we'll move into this afternoon, beginning at 1 o'clock, with House Bill 1309. Good with that?
Yeah.
Testimony? Yeah. Sure, if you want to make copies and get this to our clerk, that would be great. Or if those are copies. Anything else anyone has for me before we adjourn for lunch? All right, we're closed till 1 o'clock. We have a gavel being handed over to our vice chair, so I'm admonishing you all to be nice. Thank you.
Every committee has its own
Good afternoon. It is a little past 1. We're going to open up the hearing for House Bill 1309, and we have the prime sponsor here, Representative Weber. If you'd like to start.
Thank you, Madam Chair and committee members. This bill arises out of concern for transparency in our governmental processes. And it's something I've been thinking about for a long time, but haven't gotten to. But here's the thing. We in the House have deadlines to get our bills out. We know when those are. And when they go to the body that is not supposed to be named, they too have deadlines, so we know where the bills are and what's happening with them. And they're also docketed in our docketing system, so we know what has happened and what's likely to happen soon. And so a bill passes the House and it passes the Senate, and what happens then? Well, we all know it goes to the governor, but before it goes to the governor, it gets signed, it gets enrolled, and that's a process, and then it goes to the Speaker of the House for signature, and then it goes to the President of the Senate for signature. And they have no deadlines. And you may have noticed that some bills don't get signed till July or August, maybe even. And so I know my limits, and I didn't want to interfere with the prerogatives either of the Speaker of the House or the Senate or the President. But I do want people to know where the bills are. And I will just tell you one small example. I had, when I sat on ED&A, I had a bill that conformed the statute on commercial appraisers in New Hampshire to a federal requirement. And what we had been told in the hearing, which we expedited in February, was that if this bill was not signed by January 1st, all of the commercial appraisers would be decertified for federal purposes. And this was going to have a terrible problem for a lot of people in the state of New Hampshire. So when we got to June 28th and the bill still had not progressed to the governor's desk, I went to the Secretary of State's office and said, what's happening with the bill? And they said, it's at the Senate President's office. And I went to the Senate President's office and I said, what's happening with the bill? And they said, we don't have it. And I went downstairs to the Secretary of State's office and I got somebody from the office to come upstairs and say, yes, it is in the Senate President's office. And at that point, the way they knew that was because they had a spiral-bound notebook, which was cross-referenced only by date as to what bill had been carried where by the Secretary of State's office, because that office handles passing the bills around. And with some discussion about how do we let both representatives and our staff here and members of the public know where the bills are, this seemed to me to be the easiest way to do it. We had some discussion at some point, I think, about trying to include it in our docket system, and that's going to be a problem with our docket system, and the clerk is here to talk about that. I know there are issues with the Secretary of State's website, so that's why I referenced either the Secretary of State's website or on a public website linked to its Secretary of State's website, because I thought there might be something off the shelf that was easy to install and put up that might be easier than actually redoing their entire website structure. So the choice is up to them as to how this is implemented, and I wanted to be as flexible as possible. I just want members of the public, members of the general court, members of our staff, and anybody who wants to know, to be able to figure out where a bill is between the time it passes the second body and gets to the governor's desk. So that's the purpose of this legislation, and I leave it in your competent hands. I will just signal for the committee, my understanding was there was a certain amount of either sign-ins or testimony given online for people who couldn't be here today. But thank you.
Thank you very much for your testimony. Will you take questions? Are there any questions? Yes, Rep.
Thank you, Madam Chair. Thank you for your testimony. Are you I read through this before today, and I was kind of almost appalled that we actually need to put in legislation to facilitate something like this, that it's not just a simple IT thing or whoever the person is, someone smarter than me in that space, obviously. But there really needs to be legislation to have them enact or make a portal for this kind of stuff.
I will be the first to admit that I have had a pretty heavy-duty extracurricular time over the last year. And so I possibly could have gone to the Secretary of State's office and asked them to do this. I did not do that, and more shame to me for not having done that, because certainly they could do this. But having had a lot of experience with various agencies within the state, many of whom operate with very ancient programs and IT stuff, I know that updating things and just making a change is not always the easiest thing to do. But I also wanted to be sure we got it done. So I thought whether this bill becomes a vehicle for a conversation and a promise, or whether this bill becomes law, I wanted to be sure that we were just bringing it forward to everybody's attention.
Any other questions from the committee? Thank you very much.
Thank you for your time. It's nice to be home.
I'd like to call up House Clerk Paul Smith.
Thank you, Madam Chair and members of the committee. For the record, Paul Smith, Clerk of the House. As you know, I'm not here to testify in opposition or support of legislation. However, I'm just skirting that because this legislation will be incredibly helpful to the legislative process. It will be incredibly helpful because for months between usually May and sometimes up until October, I'm getting calls from the public saying, this bill passed on March 30th. Why has this not been put to the governor, etc.? And I can't tell them. I can't tell them where the bill is. I can't tell them if it's stalled in the Speaker's office or if it's stalled in the Senate President's office. But yes, they have stalled in those offices. As a matter of fact, a couple of years ago, a former Senate president who is still in the Senate held on to a bill until almost October. And that is a very long time when a bill passes in June. Just to reiterate the enrolling process. After a bill passes both bodies, it goes to the Office of Legislative Services. The Office of Legislative Services at that time determines if an additional enrolled bill amendment needs to be drafted. An enrolled bill amendment usually will fix typos, RSA references that are incorrect, effective dates, etc. So that's the purpose of the enrolled bill amendment. The enrolled bill amendment is then sent to both bodies, the House and the Senate, where the amendment is acted on. Now, as you know, at the end of a regular session of the House, we recess. We recess for the ability to do certain things. One of those things is adopt enrolled bill amendments. These are ministerial things. These are things that don't require a full vote of the body to do. And so we do those in recess. After the enrolled bill amendment is processed, it is then delivered from the Office of Legislative Services to the Secretary of State's office. The Secretary of State transmits the bill to the Speaker's office for the Speaker's signature. Once that's done, the Speaker sends all of those bills back to the Secretary of State's office. The Secretary of State then delivers the bill to the Senate President's office. When those bills are returned, then the Secretary of State processes them to go to the governor. And as you know, the governor has 5 days to sign a bill or let it become law without signature or veto a bill. So that's the process in a nutshell. But again, this legislation will definitely help increase transparency in the legislature. To Representative McCarter's question, the answer is yes. I do think you need legislation for this purpose because in dealing with a non-legislative body, and I'm using that term generally, in dealing with a non-legislative body, in order to make change in government, you sometimes need the sword as well as the pen. And the sword of legislation is likely the way to make things happen in this case. And as an administrator, in a sense of the website and the information that goes on our website, there are certain things, for example, the Senate amended House bills or the Committee of Conference page. Those are things that I can update via PDF. So this is something that the Secretary of State's office, regardless of whatever century they may be in, may be able to just update something as simple as a PDF on their website. So I do think, to answer your question, that it is helpful in this sense.
Representative Wall?
Thank you, Madam Chairman. I have signed bills as chairman of ledge administration before, because that's what happens in part of the process, is when the bill goes to the Secretary of State. What about OLS? Could the holdup be down there? Where's the snag occurring? Do we know?
The short answer is I don't. There is a longer answer, but we can have that over coffee sometime.
Follow up. Okay, so this bill definitely should help the process, I hope, but I'm wondering how we might find where the real slowdown is and what we might do to expedite things through OLS.
Representative, I do think that, obviously OLS, you have to remember, is handling legislation and in all aspects. They're dealing with your floor amendments, they're dealing with committee amendments. So they are, while we are also going through the process of dealing with bills in the enrolling process, we are still actively acting on legislation on the floor. So I'm loath to suggest that OLS is a holdup here. This specific legislation is just to encourage a tracking mechanism for once it gets to the Secretary of State's office, which I think is perfectly acceptable.
Representative McCarter?
Thank you, Madam Chair. So my understanding is this is only a portal or a website database, or however you want to word it, that shows where the bill is in the process. It's not doing anything to rectify the expediency of the process, correct?
It doesn't, but I'm not sure that there is a way to expedite the process in that regard. There are some political considerations. There are some timing considerations. There frequently are requests from the executive to hold the bill for an extra week because they want to do a ceremonial signing and invite all the right people, et cetera. So I'm not sure that that's a part of this conversation.
Any other questions? Thank you very much for your testimony.
Thank you.
Seeing no one else with a pink card. Oh, yes? If you'd like to come up and answer the question, that's fine.
Thank you for the indulgence. And thank you for the question. It was very clear to me that if we interfered with the actual process, this will not happen. But if the members of the public know where a bill is, they know the right person to call to say what's happening. And that might sharpen people's willingness to move it along, or people might get a very good response as to why what's happening is happening. I didn't want to interfere with the flexibility. I just want to know what's going on. Thank you.
Thank you. And seeing no other pink cards for House Bill 1309, I'm going to close the hearing for HB 1309. Good morning. Good afternoon. It is a little past 1:20, and I'm going to open up the hearing for HB 1434. And I would like to call the prime sponsor to the table, Representative Moffett.
Thank you, Madam Chair. Good morning and good afternoon to you too.
Welcome.
Thank you. For the record, I'm Representative Mike Moffett, representing Merrimack District 4 and the lovely towns of Canterbury and Loudon. So this measure, 1434, has been in the mix before. This version includes some new language and some compromises that reflect some earlier testimony and feedback that we have received. The flag design is from a national organization, Honor and Remember, Inc. And I emailed a photo of it to this committee earlier this morning, along with my brief testimony. So you should have that. And I gave a hard copy to Representative Hobson. So I understand earlier concerns about this flag. Potentially, the concerns in the past have been the flag, among others, concerns about the flag detracting from the display of existing flags. So hopefully this latest wording will address those concerns. My position is obviously one of support for the flag and for the Gold Star families who seek to have it recognized here. And some of them, I'm sure, will testify momentarily. And as some of you know, I'm a big history guy, and this type of initiative helps to keep memories and spirits alive of our fallen, while also shining some light on some history. You know, how did we lose them? Where did we lose them? Why did we lose them? So I think there's a lot of value to the flag because of the history piece of it. That's me. And along those lines, I'm going to be traveling to Camp Pendleton, California in March for the dedication of a memorial at Camp Pendleton Marine Base, honoring and remembering 29 Marines from my company, Lima 35, who were killed in 1984, 40 years ago, when the helicopter behind mine hit a mountain top in Korea. So the idea of honoring and remembering people resonates, and not just veterans. I think we want to honor and remember all of our family and friends who we lose, and in different ways. And in this case, people we've lost who wearing their country's uniform, I think particularly deserves consideration, especially during a time when military recruiting is at a historic low. This type of recognition serves to help. I think it sends an important message that military service is still valued and that those who make the ultimate sacrifice will not be forgotten. So this committee now owns this measure and obviously can further amend as desired. I will pass on Dan Colburn of Honor and Remember New England sent an email to Veteran Committee Vice Chair Skip Rollins yesterday. Representative Rollins sent it to me, pointing out that this measure specifically, if you look at the wording, it specifically mentions National Gold Star Mother's Day. I believe that's in September. Now, the committee could change that, according to Dan Colburn. You could change it to Gold Star Families Day as opposed to Gold Star Mother's Day, because they're both the same day, mothers or families, that type of thing, that wording you can consider if you'd like. Speaking of Representative Rollins, he was hoping to be here today, but he could not. He had to stay at work. As some of you know, Representative Rollins is a Gold Star father, his son having been killed in the Middle East around 20 years ago. He did send me a brief message, which I will read before I conclude here. And this is from Representative Rollins. He's the vice chair of State, Federal, and Veterans. With the committee I chair, he's my vice chair. From Representative Rollins. I won't be able to make it as we are short-staffed at work. This bill has been a long time in the making. The first couple of times it was introduced, it had too many days in which they wanted to fly the flag. Now it's been modified to fly only on veteran-related holidays. I feel this bill has a really good chance to pass this time. If we get it out of the House, I know the Senate and Governor will support it. I thought it would come through our Veterans Committee. If it had, I was going to ask to do the PI. I personally know a lot of Gold Star families. They would really love to see this pass. The biggest fear for Gold Star families is that sons and daughters will be forgotten. So this bill will go a long ways to helping them know their losses won't be forgotten. Skip Rollins. So passing it on from Skip. And by the way, for those of you watching at home, PI means parliamentary inquiry, which is offered just before a House floor vote, which helps to more clearly summarize and explain the intent of a measure just before the House votes on it, as we all know. But not everybody maybe knows what a PI is. But Skip would have wanted, or Representative Rollins would have wanted to have done the PI as a Gold Star father. So that's all I have. Thank you for your time and consideration. I'd be happy to try to answer any questions if there are any.
Thank you very much for your testimony. Are there any questions from the committee? Yes, Representative Wall.
Thank you, Madam Chairman, Madam Chairwoman, whatever. Thank you. And thank you for your testimony, and I thank all the people for being here today for our Gold Star families. Has this flag been created yet? Has anyone made it? Do we know what it's going to look like?
Yes, I think I mentioned earlier that I did send the committee a picture of the flag. So you can just go to email, and there's a picture. And the flag varies. Some of them have, well,
There it is.
there you go.
There it is.
Those of you watching from home, a flag has been, and actually, I don't mean to take over your committee, but if people that are watching on YouTube might want to see the flag,
They probably need to stand behind you.
or stand.
I don't think, I don't know that.
Madam Chairman, I
Are
don't
we
know.
allowed to do that?
Yep.
Put up.
They can hold.
Well,
it.
there,
I have
for better or worse, there it is.
Okay.
To answer Representative Wall's question, there it is.
Yeah, I'm
That's-
seeing it. Thank you.
thank
Follow
you.
up, Madam Chairman?
Yes.
Thank you.
You can take it down now. Thank you.
You can carry on.
I have a couple of questions, Representative Moffett.
Sure.
Just a couple quick ones. Where else in the country has this flag been flown? Do you know? What other states?
Question is, where has this flag been flown or approved elsewhere? I know it's a national incorporation that does this, and I'm going to defer. I think there's at least, hopefully, I see some pink cards, so some of the folks that are going to come up that are part of the movement could answer that better than me.
Thank you very much. And a final question, if I may, please. Thank you. I know when we had the POW flag legislation and such, there was a lot of question and concern about when it would be flown, where it would be on the mast and such. It will be, of course, below the American flag. How will you display this?
Sure. Thank you for the question. In the legislation, I think it specifically says this would be the last, in terms of sequence, the American flag and other flags, POW flag. This one would be the last one in terms of sequence to be flown.
May I have a final question, please? My only wonder is, not all of us, I have a flagpole at home and I have a couple flags on it. With the order in which this will be flown, is it going to be awkward? And I don't mean to offend anybody because it's a beautiful flag. How is this going to be adopted by people without large flagpoles, and the fact that it will be displayed daily? And you have the American flag, you have the POW flag, you have this. Explain that, please.
Sure. Thank you for the question. It's a great question. My understanding is that concern has been what has kept this from moving forward in the past. It's, as I read the legislation, and I'm the prime sponsor, as I read the wording that we move forward, daily is not the issue at this time. Specifically, the flag would be flown at the designated times in the legislation, which again, you could change that. You could further define or limit or expand or limit the times that it would be officially flown. I already mentioned Gold Star Mother's Day or Gold Star Families Day in September. That's in the wording, but you can do what you will with it.
Thank you very
I just have one question for you. In doing some research on this bill, I saw that it has gone before the U.S. House and Senate, and it hasn't picked up a whole lot of support. And I'm wondering if you know why.
Sure. Again, the question being why there has been concerns or this hasn't moved forward as so many people would like you to. And I'll let others speak to that as well. As I said before, I'm sure that the concerns are largely related to other flags. And this type of thing, we need to be careful in sanctioning or giving official recognition to any flag or symbol because it does set precedents, and there are other flags. Gosh, if you go to any parade, there are flags for everything. And not all of them can fly in the State House. I know the Marine Corps flag flies once a year. I'm in the Marine Corps. Those of you watching at home, Hurrah Semper Fi. So November 10th, once a year, the Marine flag flies. But to your point, or your question, I'm sure that there are only so many days and there's only so much room for flags. And so that's part of the issue and the precedent issue. And I'm sure others, some of these good folks have been working this for years and years, and they could speak to some of the history and questions better than me, I'm sure.
Thank you. Is there any other questions? All right. Thank you very much for your
Thank you.
testimony. I'd like to call up Warren Perry.
Good afternoon, Madam Chair, members of the committee. For the record, my name is Warren Perry. I'm the Deputy Adjutant General for New Hampshire's Department of Military Affairs and Veteran Services. We are the department in the state that does manage and operate the New Hampshire State Veteran Cemetery in Boscawen. We do support the bill as a department. I think no harm can come, only good can come of supporting the bill. So, there are concerns about how many flags we fly, how many precedents we set. Some veterans will tell you that we have a flag that honors our fallen, the American flag, and our fallen, their coffins are draped with it. It's presented to family members as we go. But this particular symbol will go a long way in helping honor the memory of those who have fallen. So I would just offer that that's our support for this particular bill. I think, and I don't know exactly, but I think there are about 1,000 Gold Star family members in the state of New Hampshire, one way or the other, that are considered Gold Star family. Sometimes the definition can be, were they actually killed in combat? Did they die in training? Did they die in the theater of combat operations, not related to combat operations? None of that matters to the family. The family just knows that there is a loss, and the loss is a result of some military service. And when we do things at the cemetery, when we have events at the cemetery, replace wreaths or flags on the graves of those that are there, we always ask the people that are participating to read the names on the markers, because a name mentioned or said aloud is never forgotten. This flag is another way to continue to honor that memory. I will tell you that without the legislation, the State Veteran Cemetery in Boscawen flies the flag. There's already a flagpole and a mast in our memorial walkway that the flag is flown daily there, and we will continue to do so regardless of the status of this, the fate of this bill, if you will. So pending, that's my short testimony, and pending any questions, I'm happy to answer any questions.
Thank you very much for your testimony. Are there any questions from the committee? Rep. Tierney.
Thank you for taking my question. Question I've got for you is the flag that they showed us, that was for a particular individual.
Yes.
Okay, the flag you fly at Boscawen, is there a name on the bottom?
There
or
is no name on the
that's
bottom.
left blank?
There is no name on the bottom of that, on the flag that we have at our cemetery.
Okay, thank you.
And I would just add just to say that everyone in that cemetery, regardless of their rank, how they died, their service is honored equally. So, the cemetery director very aptly puts, when he's asked, who are some of the special people buried here? And he will say, there are 16,000 special people buried here. So we don't single people out there just as a matter of course, sir.
Rep Pearson?
Thank you, Madam Chair. I'm just curious on the duration of how long you've been flying that in Boscawen. Roughly.
It's more than years. So, that the cemetery is 25 years old. I know that it was flown before the current director. He's been there for about 4 years. So I think at least 6 years, maybe longer. It's been that.
Are there any other questions?
I don't know the exact, I will caution, just caveat that I don't know the exact date, but we didn't just start flying it when the bill popped up.
Yeah, no, close enough.
Seeing no more questions, thank you very much for your
Thank you very much.
testimony. I'd like to call up Kevin Grady, who signed in to oppose this bill. It says you need 3 minutes.
Thank you.
Welcome to Legislative
Thank you, Madam
Administration.
Chair, ladies and gentlemen of the committee. For the record, my name is Kevin Grady, and I'm a 25-year veteran of the Air Force, and I'm a 25-year resident of the town of Hooksett, New Hampshire. Today, I'm here representing the State Veterans Advisory Committee, and as I don't see this committee very often, and I see a lot of unfamiliar faces, I'd like to take just a few seconds to say what it is we do. We're chartered by state law to put together a committee which has 20 members on it, and these members would be familiar to you. Names like the VFW, the American Legion, all of the services are represented as well. I represent the Air and Space Forces Association on this committee. One of the things we do is we look at all the bills that are coming before the legislature, and we single out the ones that we think have veteran impact, and then I come as the legislative chair and I tell you what we've decided about that particular bill. So with that all in mind, I am the messenger, okay, about what I'm about to tell you. We have opposed this bill since the first one came out in 2018. We opposed it in 2018. We opposed it again in 2020. And our principal argument from our members has always been that the symbol that we want on our coffins, the symbol that talks about our services, is the American flag. The honor and remember folks, I don't really have anything against them, although, I do take exception maybe a little bit in paragraph 2 where it says they're a national organization. These folks are a commercial concern. They make money off of these flags. So while they may have good intentions, and we know that they do, somebody makes money for that corporation off of this. And it's not like a national organization like the VFW or the American Legion. It's a commercial concern. And so when you have a bill like this that basically mandates that we're going to, and we already have one for the veteran cemetery, so good there. We're going to have to procure one for the State House, according to this bill, to go up there. And so somebody's going to essentially sole source award this kind of government contract, small potatoes though it may be. They're giving this to these folks. So that has been some of the argument. Some of our positions have softened over time, unfortunately. And I asked them twice. They said this is not one of those ones that we're ready to soften our position on. Now, like Colonel Perry said, if this bill goes forward, life goes on. We'll all salute smartly and move on. We're all military folks. That concludes my testimony, unless anybody has any questions for me about why we came to the conclusions that we did.
Thank you. Are there any questions from the committee? Thank you very much.
Bill, no, I have no ill will towards anybody that's a supporter of this bill. One of my students, I was a junior ROTC instructor. His name was Captain Ryan Fanuff, was the last air casualty of the Gulf War, died in an airplane crash in February of 2020, right before COVID. So I understand where these people are coming from.
Thank you.
Yes, ma'am.
I'd like to call Mark Decotu. I'm sorry if I mispronounced that. You are in support of the bill, and you have
Yeah.
written down 3 to 4 minutes for your testimony.
Yes, Madam Chair.
Thank you.
Thank you, Madam Chairman. My name is Mark Decoto. I'm a Gold Star father, and I've worked with Honor and Remember for many years. We lost our son, Army Specialist Mark Paul Decoto, on January 29th, 2010, in Wardak Province, Afghanistan. My wife Nancy and I live in Thornton, and I thank you for this opportunity to speak to you in support of House Bill 1434. Honor and Remember Incorporated is a national 501c3 nonprofit organization which coordinates activities and ceremonies across the country to honor and remember every American fallen service member and recognize the enduring sacrifice of every family who has lost a hero in service to our country. There are many ways that the organization seeks to carry out this very important mission. First and foremost, the group funds and presents Honor and Remember flags to family members who have lost loved ones in service to our nation. Families of any service member who has died under any circumstances, whether it's direct combat, training, or as a result of service in any conflict from the Revolutionary War to the present day, are eligible to receive a flag. Honor and Remember here in New Hampshire has recognized and continues to recognize service members from World War II, Korea, Vietnam, the Cold War, and the global war on terrorism. As an example are the two Crafts brothers from Manchester. The brothers were both UNH graduates, and they were captains in the United States Army during World War II. The brothers were killed a few weeks apart in the European theater, and we presented Honor and Remember flags for each of the captains to their sister, who's the only remaining direct relative of them. And our Gold Star family members and volunteers are actively seeking out the families of others to honor in this special way. We feel that it is critical to let these families know that the service of their loved one and their personal ongoing sacrifice is not and will not be forgotten. As has been stated, we have submitted bills in the past, and you may hear that in the past, it's been said that our organization wants to somehow replace the American flag and that we want the Honor and Remember flag to drape the coffins of returning heroes. I assure you nothing could be further from the truth. We want the Honor and Remember flag to be a way to recognize Gold Star families for their sacrifice and to keep the memory of their loved ones alive. Our family has received several American flags to honor our son. One flew over Forward Operating Base Nunez in Wardak Province, the place where Mark was killed. Another one flew over his unit's headquarters at Bagram Air Base in Afghanistan. And the final and most special one was the one that covered his casket. These 3 flags are memorials to Mark, and our family has decided that they will never be flown again. We also have an Honor and Remember flag similar to the one you were shown that has his name on it. It flies regularly at our house, and we take it to the New Hampshire Run for the Fallen every year. We show it to children at the Waterville Valley Elementary School when we talk to them about Mark and others who have served and sacrificed for our country. This is our way of sharing our son with others outside of our home. This is the sort of emblem and purpose that we are asking you to support with this bill. We remember to maintain the link with Mark Paul. As a nation, we remember our war dead to help build an appreciation for what we have and to recognize the sacrifice of service that members who have died and their families have made for our country. We need to teach the majority of our country about the willingness to serve and the sacrifice it takes to maintain the sovereignty of our nation and to protect our way of life. No loss of a service member is insignificant, and we need to make sure that everyone in New Hampshire is aware of the debt that they owe to those who have sacrificed. Thank you for considering this legislation, and I'm available to take questions if you have any.
Thank you very much for your testimony. Representative Wall?
Thank you for your testimony. My deepest sympathy to you and your family for your loss. Was your son's funeral a military funeral?
Yes, it was.
I just wonder, and I have no opinion one way or the other. With my folks, my parents were both military.
Yes.
And they had military funerals as well. The American flag was on their caskets.
That's correct.
You said that this remembrance flag was on your son's casket.
No, I'm saying that that is not what we want.
Oh,
Our
okay.
son had an American flag on his casket, and it is fully my intention as a veteran myself. I would not want it to be any different than that.
Okay, thank you. I was just wondering if I misheard, if it was the protocol or what.
Right.
And again, I'm so sorry. Thank you.
Thank you.
Are there any other questions? Thank you for your
Thank
testimony.
you, Madam Chair.
I'd like to call up Andy Cruz, who's in support of the bill. And you have here, you need 5 minutes for your testimony.
I'll be quicker than that.
Thank you.
Thank you, members of the committee. I am here testifying in support of this bill. I am a Marine veteran, Desert Shield, Desert Storm. I am a lifetime member of the VFW. I'm a part of the American Legion. I have been very active in veteran services and causes throughout the state of New Hampshire. I was one of the founding members of Veterans Count, who works with Easter Seals, and I am now a board member and founder of Swim with a Mission. Swim with a Mission, if you're not familiar with it, it's 501c3. We have partnered with the state recently on the Gopher and working with the state and actually processing those grants for veteran organizations. We have basically, as an organization, helped fund those veteran services that are in need. And in our state, there's a great need to it. As a population, we actually have a higher population per capita than most states of veteran services. We take a lot of pride in that in the state, and we have worked very hard to become one of the most veteran-friendly states in the country. Most recently with Franklin and working on that center, which is going to be a huge win for our state in attracting military families, which I think provides great services. They're great workers, they're great families, great constituents for our state. And we want to continue to be veteran friendly. But there's nothing I could say we could do more than honoring the Gold Star families. You know, for veterans who have passed, you know, they've gone on and they paid the ultimate sacrifice. But these families live on, and they have that pain and suffering on a daily basis. They come to our events. We carry every one of our events. We have a memory wall that has a name of each one of our fallen for the state of New Hampshire. And these families come out to be able to see those names and remember their individual, their child, their brother, their sister, and it gives them a sense of purpose. And I got to tell you, it's a great, right now, as they had mentioned earlier, recruiting, with it being down with military service, I can't think of a better thing we could do here at the state than to honor those that have fallen. Because folks, you know, I commend you because y'all have decided to serve the state and you serve it willingly, but freedom is not free. So I would appreciate y'all's support on this bill. Thank you, and I'll open up any questions.
Thank you for your testimony. Any questions? No questions. Thank you very
Thank you.
much. I'd like to call up Geraldine Duncan, who is in support of this bill, and you need 2 to 3 minutes for your testimony. Thank you.
Thank you very much for having me today. I'd like to start by giving you a little background on my interactions with Gold Star family members. I'm a military spouse of 40 plus years. When our recent conflicts have happened, my husband was the New Hampshire Army National Guard Chief of Staff. So a lot of times when we had losses in this state, our faces were oftentimes the first that family members saw. We have continued those relationships, some going on 20 years. And one of the things that we've seen that brings comfort to our families is this flag. My husband is a West Point graduate, 79, a true patriot, and flag etiquette to him, he sees sometimes what has been done to our flag, and it often brings him tears. So when I first approached him with this Honor and Remember flag, he was, like many others, absolutely against it, because we do have an American flag. And what that symbolizes is extremely important for him. He fought for that in combat in Afghanistan, came home with both physical and non-physical wounds of war. And when we've talked about this, he is in full support of this flag, because he again has seen what it's done for our family. He again has taken a step back and really looked into what we're asking for. There are 27 states in the country that have adopted this flag. It is clearly stated on any of their material that they put out, it will always be subservient to any other flag that you would fly, to include the POW MIA flag, to include any other flags. Oftentimes it's actually flown separate on a different flagpole, because it does get messy, right? And as visual people, we just don't want stacking. So what we're asking now is for 5 specific days. And oftentimes, again, we've been doing this for over 2 decades, there's such an outpouring of community support when we lose a military service member in any way. We lower the flags. There are hours and hours of waits when we attend funerals. There are lines or processions, and guess what? Most of that goes away. And the only thing that we hear from our families is that their children, their loved ones, their spouses are remembered. And this is just, I feel, a very small ask for them to be able to be considered, so that the education can go out in communities. Because when you see the American flag, everybody's thinking, again, it's a symbol for all of us. But if you were to walk down your neighborhood and see this beautiful flag flying, you might stop. And if somebody's out gardening, ask them about it, right? And they get to tell that story of their loved ones. So I really implore that you take the time and really look at, there's a website that explains it all. 27 states, always subservient to other stuff. So there had been for many years, and we're not giving up. So we have just, kind of let people come up with their own ideas of what the purpose is. And the purpose really is to give back to those families who have given that ultimate sacrifice.
Thank you very much for your testimony. Will you take questions?
Yep.
Are there any questions from the committee? Yes, Representative Wall.
Thank you. Thank you for telling us that 27 states have adopted this. I've been wondering that. Do those states have the same requirements that this bill is asking?
No, so it's a different legislation. So some of them fly it at all times, so it's different per state. And
Good enough. Thank you so much.
thank you.
Seeing no other questions, thank you very much.
Thank you.
I would like to call up Representative Grotto. Welcome to Legislative Administration.
Thank you so much. I'm Representative Jackie Grota. I'm here representing Rockingham 24, which are the towns of Rye and Greenland. Blake Marston, whose name is on that flag, would have been one of my constituents because his mother is a constituent of mine. And she brought this idea to my attention, and that's why I co-sponsored the bill. We have above our Capitol an American flag, and underneath that American flag is a POW MIA flag. And that flag flies daily to remind us all of those that are missing in action or prisoners of war that are in the military. This bill is not very complicated. It only asks that we fly the Honor and Remember flag 5 days a week underneath the state flag. And if the cost of the flag is an issue, I can assure you I'll be glad to provide it to the state as a gift. The flag, to me, completes the story. When someone's missing in action and they've been found, that family receives a gold star. And that, to me, closes the chapter for that family and for that person. However, those individuals live forever in our hearts and should be remembered and should be honored with this flag on those 5 days a week above the state capitol. Thank you.
Will you take any questions?
Absolutely.
Thank you. Any questions from the committee? And you said it's 5 days a year, correct?
Did I say 5 days a week?
Yeah.
I'm so sorry. It's 5 days a year.
Thank you.
Yes, thank you.
Thank you for your testimony.
Thank you.
I'd like to call up Jim Moody, who is in support of this bill, and you have 3 minutes for your testimony.
Yes, ma'am.
Thank you.
Thank you for allowing me to testify. My name is Jim Moody. I live in Hooksett. I am a retired Army National Guard member, 31 years of service. My sister and brother-in-law are both Gold Star parents. They lost their son to suicide after returning from Iraq. As was mentioned, the Honor and Remember flag does not replace any flag, and that was never the intent. It recognizes the sacrifice made on behalf of our country. I have various folded flags in my house. I have one that was flown over the state capitol here that I was given upon my retirement. I also have flags that were draped in both of my parents' coffins, who both served in the Army. Unless you come into my house, you have no idea what those flags represent. You see a folded flag, but unless I tell you specifically what it is for, you will never know. My sister and brother-in-law are the same way. They have an Honor and Remember flag, and they just moved into a new house, and as soon as their flagpole is up, that flag will fly proudly below the U.S. flag. But right now, they have a folded flag for their son Derek in their house. But who sees that besides them? Nobody knows of their sacrifice unless you personally know my sister and brother-in-law. The Honor and Remember flag is an outward symbol of a family sacrifice, so everyone can see and understand the cost of freedom. I will mention two things. One that Mark Dakota mentioned, the Run for the Fallen, and one that Andy Cruz just mentioned about the recruiting woes for our military across the board. Mark mentioned the Run for the Fallen that is held every year to recognize those from 2018 on, was basically any service member that was lost in the global war on terror, either directly through training or suicide. This year, my sister and brother-in-law went to the Run for the Fallen in New Hampshire, and besides the immediate family members there and the runners, there was no one else. No one else remembered their sacrifice. This is definitely a way where 5 times a year, as a minimum, the state of New Hampshire can recognize those that have served our country and given their lives for our freedom. Thank you.
Thank you for your testimony. Will you take questions?
Yes, ma'am.
Any questions from the committee? Seeing none, thank you very much.
Thank you.
And I'd like to call up Patty Cloutier, who's in support of this bill. You have written down 15 minutes for your testimony.
It'll probably be less than that, but I was just,
Okay, thank you very much.
I've never been to one of these, so
Well,
bear
welcome,
with me.
welcome to Legislative Administration.
Well, thank you very much. My name is Patty Cloutier. My son was Specialist Sean Michael Cloutier. May 19th, 2019, my son took his life while serving. I have received a flag from Honor and Remember. And I look at it this way. This is my outlook on this whole situation. These servicemen and women just die in honor of our country every day. They sign a blank check for their sacrifice, and then they cash it with their lives. Why shouldn't we have the chance to honor them and honor the sacrifice that they make every day of their lives? Thank you, and I'm opened up with questions.
Thank you for your testimony. Are there any questions from the committee? Seeing none, thank you. And the last person, Jared Mostow? Marston. Welcome to Legislative Administration.
Thank you for having me. My name is Jared Mostu. I'm trying to get through this. 9 years ago today, we lost my cousin Blake. He's the name that was on the flag that you saw earlier. I have a quick note that I'd like to read for you guys. This is written by my youngest son, who was named after Blake. My name is Noah Blake Mostu. When I'm at my niece's house, we put out a flag every day. I always ask to put out the Blake flag because it reminds me of Blake, and that's my name too. I'm only 8 years old, but I know it's important to remember. We salute the flags and say, "Good morning, Blake." Lots of people see the flags, and I think it's good, and I feel proud. My aunt flies this flag on her own every Sunday. She flies the American flag every day. I have a flag in my house that's folded up that was carried by Blake on his first tour in Afghanistan. I know my brother has a flag from him as well. It means a lot for our family to see this flag fly, whether it's Blake's flag at my aunt's house or one that flies over the State House, and we hope that it will. I've had multiple opportunities to talk to people who will walk by my aunt's house, and they ask, "What is that flag, and what's it for?" Because they don't know. And it provides an opportunity to have that conversation so that people do understand that our military members are sacrificing themselves for us, for our freedoms, so that we can go about our lives in comfort and knowing that they will not be forgotten. And it just allows us another way to remember them and make sure that their memory stays alive forever. I don't know exactly the best phrasing for this, but when someone dies, they die twice. The day they die, when their soul leaves their body, and the second death is the day that someone's name is said for the last time. This allows us another way to make sure that never happens, regardless of when someone served or when they passed. Thank you. If you have any questions, I'm more than happy to answer.
Thank you for your testimony. Are there any questions? Seeing no questions, thank you very much.
Thank you.
And I don't have any more pink cards, so I'm going to close the hearing for HB 1434. And it is 2:05, and I'm going to open up the public hearing for HB 1096. And I will call the prime sponsor, Rep. Gallagher. Welcome to Legislative Administration Representative.
Hi, so I'm Eric Gallagher, representative for Merrimack County District 20, which is Concord Ward 6. Well, I've actually got two bills here today, but I guess starting with 1096, enabling the State House Visitor Center to sell state symbols that may have intellectual property rights holders. So basically, where this idea came from was just in our previous term, I believe we had a bill to add an additional state song to our list of state songs. And I believe that some of the points raised during that debate were, oh, well, we have a lot. How many is that? It was like 10 or something. And I was thinking, oh, hey, that sounds like the perfect length of an album. And so I decided to go ask the gift shop if they could sell an album of all of our state songs, and they said they weren't really quite sure because of some of them have intellectual property rights attached to them that that they weren't quite sure how to handle. So this is basically just to clarify that situation. Yeah, it's so yeah, we have a big state symbol section. So it mentions such as state songs. It would presumably also apply to other state symbols with like I think there's state poems or something too that this might also apply to. Yeah, it's a pretty simple bill, just 4 lines. So I'll take any questions now.
Thank you very much for your testimony. Are there any questions from the committee? Rep. Pearson.
Thank you, Madam Chair. Representative Gallagher, thank you for coming today and presenting this legislation to the committee. You mentioned a state song as an example, and some other state symbols. Are you aware that in most cases, when those are adopted, the creator of those surrenders their rights to those to the state as part of that process?
If that's the case, then that's good to hear. The thing is that, well, it's just a point that there hasn't really been much clarity on. Like, I remember it coming up in the previous debate we had about adopting a new state song was about the intellectual property rights. And then also, just for figuring out why we weren't already doing this, it's just because there was some uncertainty. So, yeah, if they already can, then if this is already handled, then that's good to hear. But I just think some additional clarity would be useful to make sure it's specified explicitly.
Thank you very much. Representative McCarter.
Thank you, Madam Chair. Thank you for coming today, Representative Gallagher. I did have, albeit a brief description with Virginia from the gift the gift shop today, last week, maybe, I think it was. She did say she was going to come today. Is she here?
Yeah,
Oh,
I see her
good.
in the audience.
I'd be interested if you can listen to her explanation about the intellectual property type of arrangement, and with its state symbols having to have approval from the Secretary of State's office, because they're almost not copyrighted, but it's similar type of protection on those symbols. So I wonder if you've thought about maybe speaking with the Secretary of State's office as well.
I mean, yes, I talked with Virginia myself when preparing this bill. I don't think she mentioned anything about the Secretary of State's office at the time, but having that additional lead is useful. And yeah, if I mean,
Well, Virginia is going to speak after you, so she can
Okay,
probably
yeah.
speak to that.
I was just looking to see if there's anyone from the Secretary of State's office in the audience, but I don't recognize anyone. So
Right, thank you. Is there any more questions? All right, thank you very much. Oh, are you, Rep Wall, are you all set?
I was just going to say that patents are registered with the U.S. Patent Office in Washington.
Thank you for your testimony. And I'd like to call Virginia Drew, who signed in to oppose this bill. Welcome to Legislative Administration.
For the record, it's Virginia Drew, the State House Visitor Center Director. I will say I've been in the Visitor Center for over 20 years. I appreciate Representative Gallagher's intent to try to make things easier and hold other items in the Visitor Center, but I did discourage that. This legislation I didn't think was necessary. I still feel that. I will do clarification. The Secretary of State holds the authority over the state seal. And in the Visitor Center, we have approval to have certain items with the state seal. Anything else, we basically stick to very general items in the Visitor Center. And thank you.
Thank you very much for your testimony. Will you take questions?
Yes.
Any questions from the committee? Rep Pearson.
I'd be lost in this incredible opportunity to have you on the other side of a microphone. So, but in the sense that the Visitor Center does sell a product to the public and to the folks that do come to this very, very ancient state house, have you found the desire for people to come and purchase something that you can't sell that would fall under the intent of what we're doing here?
No, it hasn't come before. And I did mention that there are a lot of items that are state symbols that would not be appropriate to carry in a visitor center, such as pumpkin, spiders, potato for the dairy folks.
Any other questions? Thank you very much for your testimony.
Thank you.
And seeing no other pink cards for HB 1096, I'm going to close the hearing. It is a little past 2:15. I'm going to open up the public hearing for HB 1367. And we have the prime sponsor, Rep. Gallagher, back on the hot seat.
Yep. Hi. So yeah, again, I'm Representative Eric Gallagher, representing Merrimack County District 20, which is Concord Ward 6. I'm here now to introduce House Bill 1367 relative to establishing immunity for certain testimony in public legislative hearings. So, yeah, as legislators, basically what we do here is we make determinations, we make laws about things about what we think should be legal or illegal. And when we do that, we have this process where we have hearings like this one to discuss the activity in question. And we're actually kind of unique in New Hampshire here in that we have open public hearings where anyone can come testify. And I think that's a good thing. I think being able to hear from as many people as possible is a great opportunity that we have before us. So sometimes when I've been trying to convince people to come testify about something, they've expressed some concern that their testimony could get them in trouble somehow. So I have introduced this bill to basically try to improve the amount and veracity of the testimony we receive in hearings like this. Yeah, I think we should be making our decisions with all the relevant information available, especially from the people in question who bills would affect. Yeah, about this bill, so it's neutral in terms of it's not necessarily pro-legalizing things or anti-legalizing things. It would protect both kinds of testimony, like both people saying, oh, this illegal activity caused a lot of harm to me and I believe it should be restricted further. Or also the testimony of, oh, this illegal activity is actually harmless and should be legalized. I discussed this legislation with the ACLU. One concern they said I might face would be like, oh, well, people might ask, oh, well, couldn't someone take advantage of this to get away with murder or some other heinous crime or something? And so I took that feedback and put in a redraft request, which is reflected in the bill, to add the relevance criterion, the part where it says the order of immunity shall be restricted only to cover testimony concerning potential criminal conduct related to the statute that is the subject of the hearing. So yeah, for example, with for this bill, HB 1367, the statute in question is RSA 14, section 14C. So it would be only testimony related to that portion that would be covered. And also the chair has to, this is a decision being made by the chair of whether or not to grant this or not. So I personally think those two factors, the relevance criterion and the fact that the chair has to grant it ought to be enough of a safeguard. But if the committee would like to add additional safeguards, like say maybe distinguishing between violent and nonviolent crimes, or maybe distinguishing between misdemeanors and felonies, or certain classes of misdemeanor, I'd be open to that too. The only reason I didn't do that myself is because I wasn't quite sure how to go about wording it specifically. So, yeah, I think this bill is consistent with existing principles of law. We've got the Fifth Amendment right against self-incrimination that implies in court proceedings. I think that we should make sure to clarify that it applies in legislative hearings too, so that way we can get the best testimony with which to make the best decisions about the bills we consider. And I'll take questions now.
Thank you for your testimony. Rep. Pearson?
Thank you, Madam Chair. Representative Gallagher, are you aware that when you testify in front of a House committee, you are not only are you not under subpoena, but you're not under oath. So therefore, no one is ever required sitting in that seat to answer a question that's brought before them by a House committee.
Well, so yes, that's true, but sometimes there can still be kind of a chilling effect in the first place of somebody who thinks that they might be put in a sort of situation where that comes up. It's not. It's more about being able to make it easier to convince people that it's safe for them to testify, yeah, I think the current way to do that would be just to not answer a question. I think it would be better if people could answer the question and provide the full information rather than having to go the not answering the question route, just so we can get the full information.
Thank you. Are there any other questions? Rep. Tierney?
Thank you, Madam Chair. Thank you for taking my question. So your bill is proposing that an individual sitting as chair that in most cases probably has no legal experience whatsoever is going to make a decision as to immunity for somebody testifying?
Well, I mean, we're the fact that we're not lawyers, we still make laws about this in the first anyways. I don't see how the fact that we're not lawyers really would restrict the decision to grant immunity any more than it would to make the law in the first place.
You're right. We make laws here. And many times they get struck down by lawyers in the Supreme Court or a lower court first and then the Supreme Court. What you're proposing would grant folks to come up here and say, okay, I know cannabis helps medically, but it also helps my mood. So that's why I smoke it, even though that's illegal.
Yeah, I think that it would be useful to hear from people.
Right, but they're breaking a law
Yeah.
that currently is on the books And according to this, Representative Sheehan would be able to say, you have blanket immunity on, or you'd have immunity for your testimony. And she's not a lawyer knowing where does this fit in the pecking order for immunity and for the law.
Well, so yeah, so one other thing to mention is the immunity applies specifically to their testimony that they're providing. So yeah, it's not like a blanket immunity. It just means that their testimony specifically that they're providing here for the purposes of us being able to decide how we want to vote on things can't be used against them.
Representative Wall.
Thank you, Madam Chairman. Thank you for your testimony. I've been here a long time, and I served about 30 some odd years on the Judiciary Committee. We dealt with some very, very sensitive issues, and people could have gotten into some kind of problems, as you're suggesting. But usually when people testify, they're testifying purely on the facts and not on their behavior or something like that. We do have, with our right to know law, specific times when we can go into non-public session. I've never known a committee in this House to do that, except the Ethics Committee. And I can't imagine a committee where immunity would be necessary, except on something like the Ethics Committee. And again, we have the right to know law, which is very specific in terms of when we can offer people the chance to go into non-public session and not feel the judgment or concerns of others. Are you aware of that?
Yes, I am familiar with 91A and that it has provisions for non-public sessions. I was thinking more that I don't think people should have to be in private to be honest with their testimony. I think they should be able to do that in public as well.
Rep. McCarter.
Thank you, Madam Chair. So, Rep. Gallagher, I can understand where you're, I kind of almost understand where you're coming from with this. However, you could certainly explore many different types of subject matter for statute building that we do here every time we're in session, in a meeting. Let's say, for example, somebody wants to put forth a bill for, I don't know, a brothel. They're legal in New Hampshire. That's what the intent of the bill is. Does that make it what the behavior is legal now? No. So you're going to want to have people come in and testify to how wonderful it will be if we have brothels all over the state. We already do it. You don't know about it yet, or it's under the radar. You're going to have people coming in to try to sell the idea. Why wouldn't they just come and sell in hyperbole? Wouldn't it be nice if, instead of saying we already do this, it's the same, they're giving the same information, they're not admitting to anything, they're not saying they don't either, though. So where does the social hierarchy start? You're looking to not have them held criminally liable for their testimony, but that doesn't remove the social consequence or perhaps employment consequence should their boss be watching the YouTube stream of this committee. It doesn't remove any of the other, a stigmatic one. It just removes law enforcement's ability to utilize that in a fashion that's already designed in statute. So I think it's more of a package, what you're trying to accomplish here, than just removing, the criminal aspect of this. Am I incorrect?
I mean, I think the criminal aspect is pretty much the only thing we can modify through the law. The rest of the stuff, like cultural stigmas and stuff, aren't really that's not the law isn't the right avenue to be addressing those sorts of things. That would be like we just have to convince people not to stigmatize people who decide they want to be honest and make confessions about things that they've done.
Oh, follow up? Yeah.
So, being the structure of a legislature that we are, wouldn't you think that it might be more of a reasonable avenue for someone, this fictitious person that we're talking about in this circumstance, they go to their representative and propose something, hey, why don't you get out there and make this legal, right? And then you being the representative, maybe not you specifically, the mayor or whomever, we're supposed to go and advocate for the proposition or the proposal and try to get buy-in from the other legislators. So that doesn't necessarily mean that person has to come and testify for something that may be deemed as a criminal activity. It's the way the representative comes in and makes the proposal in hypothetical terms. I just don't see where this legislation is needed at this point.
Well,
I don't.
so yes, you could send someone else to testify on your behalf, but I think secondhand testimony is never really quite as good as firsthand testimony. Like we're all familiar with the game of telephone here, right? You know, where you pass a message along between a bunch of different people and get a different result at the end. I think that's something to worth addressing, is to try to avoid the information loss that comes with having to send someone else to testify for you.
Rep. Notting Wong?
Hey, just wanted to ask if this is an issue you've run in a lot, and if it has happened more recently since we've started streaming on the internet.
I mean, this is only my second term in office, so I don't think I've really been here long enough to be able to make any sort of timescale comparisons. But yeah, it is something that I have encountered when talking with constituents or members of interest groups who might be interested in testifying.
Any other questions? Yeah, Rep. Pearson.
Thank you, Madam Chair. At the end of this, you specifically address criminal cases. You do not mention civil cases. And was that a consideration that you gave when you drafted this? Or was that an oversight to leave the civil side of the law out of this?
I think criminal cases are my primary concern. Yeah, that's just how I'm going to answer it. I just think that criminal cases are my primary concern here.
Seeing no other questions, thank you very much for your testimony.
Yep.
And Rep. Gallagher, do you have written testimony you can submit?
Not beyond. I sent an email to the committee when we were talking about like the scheduling for today. That included some written testimony, but I don't have anything beyond that though.
Thank you. And the last pink card for HB 1367, Tricia Nwalu. Sorry. And then you're in support of this bill. Welcome.
Oh, there we go. Good afternoon. My name is Trisha Navalu. I'm here representing myself and my community. Throughout my career, I have used an alias. And in fact, most of the community that I work with uses another name for safety precautions. I am the founder of Erotic Laborers Alliance of New England. We offer resources to consensual adults engaged in sex work. We are also an anti-trafficking group. Granting immunity when giving testimony for certain community members concerning possible criminal conduct would increase their sense of safety when coming forward, and it would encourage testimony of their lived experience. These marginalized voices of both consenting adults and trafficking survivors who face violence, discrimination, criminalization deserve to participate in democracy. They deserve to feel safe when doing so and be granted immunity. A good example would be a human trafficking survivor that wants to talk about her personal experience about trafficking, but in doing so would be admitting criminal activity such as prostitution. We can all agree that we want to hear real life testimony and that we should not be sending the police after her to make a prostitution arrest. Similarly, a person who wants to talk about their drug addiction struggles in a drug policy hearing perhaps should not be targeted or criminalized afterwards. It was here at this State House where I first outed myself. I went on record with my real name as an erotic laborer. We worked a lot with bipartisan support, and we passed a healthcare bill of rights and an immunity from arrest or prosecution for prostitution bill. We worked with law enforcement then, and we would gladly work with law enforcement any other time. Since then, I had a stalker sending mail to my house, knowing exactly where I live. That was very frightening. And I cannot say without certainty that using my real name publicly here at the State House did not contribute to that. Regardless of my chosen profession or the various professions of the marginalized community of erotic laborers in New Hampshire, our community would like to be granted some sort of immunity when we're sharing our voices. We would like to avoid possibly being targeted for harassment or criminalization. And that's why we support this today. I'm open to any questions you might have.
Thank you for your testimony. Are there any questions from the committee? Seeing no questions, thank you very much.
Thank you. Thank you for your time.
Oh, the testimony that you read, can you send that to our committee?
Yes.
Or do you have printed copies today?
Oh, I ran out of ink, but I can email it.
That would be great. Thank you very much.
All right, thanks.
And seeing no other pink cards, I'm going to close the hearing for HB 1367. And that ends our agenda for today.
Madam Chair, when are we meeting again? Do we have a date on the calendar?
This is tentative. It's not set in stone yet, but I believe we're going to meet again on the 31st. Stay tuned for the exact time. Yeah. Well, we have other bills in our committee that will probably, yeah, correct.
They should